Can I just say something about Andrea?
Good morning, everybody. Welcome back. Pardon my rather informal situation here. And tech-wise, this is not going to be the ideal stream for me. I am micless, and the AI, whatever it does to like correct my light or whatever, it does all kinds of strange things, like if I move at all. So no production value here, but that's okay because we're not here for me. We are here for the hearing. So, as many of you know, I was not here Monday. I missed the ruling because I was way back in the backcountry in part of one of our nation's greatest creations, the national park system. Such a fan of our national parks and the just beautiful, glorious works of nature that they have protected for us. So I was way back in Sequoia, in kind of little off the beaten track area. No cell signal. It was very blissful. But that meant, of course, I had to get a little bit caught up when I got back into civilization, which I have done my best to do. So the Substack, of course, you can find up at the QR code, or just, put my name into Substack or whatever. Links are in the description and everything. But that's where I have the legal archive, and so I have gotten that updated, pretty much up to date. There have been a lot of new filings, but nothing really extraordinary. It's just more of the same of what we've already seen. A lot of litigation over cameras and the cameras in the preliminary hearing. But Monday's hearing was interesting. It was not surprising to me in terms of the outcome, other than our surprise hearing today that I wasn't prepared for. Judge Graf was not, he didn't want to rule on the contempt motion yet because there had been pleadings filed in kind of the recent days. And so he wanted a chance to review those before he made his decision. That's primarily why we are here today, is to get the ruling on contempt. But then there was also the issue of the out-of-state subpoena to Lance Twiggs, and he ruled that that was not going to be authorized under the rules and the standards that Utah applies for the defense to call witnesses at preliminary hearings. And that was mainly because we talked about this before. They didn't have a proffer of any specific testimony that they anticipated getting from Lance that was likely to undermine the probable cause determination. What they wanted to do was to elicit, through cross-examination, I think largely information about his immunity deals, which we learned about last time. He's been given use immunity, which means that the statements that he made cannot be used to prosecute him. It does not preclude him from being prosecuted based on independent evidence, should they develop that and should they be inclined to go down that road. But as of this point, of course, we don't know of any charge against him, and because his statement can't form the basis of it, they are largely treating him as cooperative, it appears. So interesting state of affairs. But that also triggered another issue that we may or may not get resolved today. There was some discussion that they would try to brief it and whatever, but that hasn't happened. Those haven't hit the docket. So we may be back for another one of these like quick hearings next week. We'll have to see. But that involves the defense wanting to call a number of the forensic experts, sounds like largely from the FBI and the ATF, to testify live at the preliminary hearing, rather than, kind of like with Lance, rather than relying on their reports and the reliable hearsay that Utah allows to be presented at the preliminary hearing. And so in light of the ruling on Lance Twiggs, the defense was like, it's not clear if you're gonna, find that these experts are allowed to testify live either, and we don't want to fly them all over from the East Coast if they're just gonna be, turned right around at the courthouse door and sent home. So we may or may not address that. There was some suggestion that they would try, but we have not seen any of the briefing on that yet. The last thing that I do expect we'll get a decision on today is the cameras in the courtroom for the preliminary hearing. Judge Graf issued a like decorum order, kind of an interim order just for the preliminary hearing, that people in the audience are not going to be allowed to bring devices, no cell phones, no laptops, no Apple watches, like nothing, no Google glasses, nothing like that. I think they're very concerned about the risk of, you know, just some kind of surreptitious recording or something like that. So all of that is going to be banned. But of course, you know, the audience is allowed in. The question is whether, you know, we from home are going to be allowed in through the view of the camera lens. I'm not real concerned about that, just given the, you know, friendliness that Judge Graf has had to the cameras so far, as well as the presumptions in Utah that cameras are good. And so I'm expecting that cameras are going to be allowed. Pen and paper should be totally fine. Yes, they can't like say you can't take notes, right? There's nothing violating the decorum of the courtroom by sitting in there and taking notes. So I would anticipate that is perfectly fine, but just no electronic devices because it will increase the risk of somebody doing something that they shouldn't be doing. So I do, give me a second here, the WebEx, okay, there we go. The WebEx has been slow to let me log in, but it is now letting me log in. So I'm going to go ahead and connect it so we can be ready when it gets started. All right, and there they are. All right, go ahead and. Oh, yes, I'm muted. All right, everything should be good to go here. So yeah, that's kind of what's been going on as we wait to get started. Obviously at this point, the big thing is just the preliminary hearing is really right around the corner. And you know, as much as I would like to think that it's going to settle a lot of some of the factual questions and things like that around the case, I don't know that it will. You know, I think it is going to be, of course, our first close look at what some of the evidence is, since we got the affidavits of probable cause and the information that describes the probable cause to charge Tyler Robinson with the crimes. But those documents have like described what the evidence is, and because the preliminary hearing does allow the hearsay, and it sounds like that is largely how the prosecutor intends to present their case, it's still a situation where we're not going to necessarily see a lot of stuff for ourselves. We're going to hear them talk about it and maybe hear them describe things, and maybe read about stuff that you know people have said, findings that they've made, and stuff like that. But I'm not anticipating, for example, that like all the videos are going to be published to the audience, to the cameras in the courtroom. I'm not anticipating that things like, we know that they will enter the autopsy report into evidence, but are they going to like read it? No, you know, there's going to be a lot that is available, made available to the court through this process, but not necessarily revealed to the public through the hearing. But nevertheless, you know, it will be something. It will give us the broad outline of what's expected to be presented, and so, you know, hopefully maybe it will answer some questions. As far as why the hearsay testimony is allowed, it's largely because the probable cause determination itself it's an extremely low bar to clear. It's just whether or not there's justification to charge somebody with a crime. If there's enough there to think, you know, reasonable chance this person did it, then they're justified in bringing the case forward to a jury. And then once it gets to the actual trial, of course, the standard is significantly higher. You got to be convinced beyond a reasonable doubt. So because the standard is low, they don't really want to go through this whole kind of, I don't know. It's just it doesn't need to be a mini trial, you know, with live witnesses and stuff like that. I think the reasoning behind it is particularly evident in cases not so much like this one. I mean, maybe a little bit, but like domestic violence cases and certain bad types of assault cases where just literally the process of being in court and having to talk about what happened and relive it and stuff like that, this can be extremely traumatizing. And Utah does have a very strong victims' rights protection. So I think there is a desire to minimize that, and so yeah, in light of the lower standards, they don't consider hearsay to be a problem at this particular stage. It does have to meet certain qualifications. It can't be just any hearsay. The cop can't write a report that says, it's like reporting gossip that they obtained from the community or something like that and call it good. It does have to meet some minimal standards. So for example, the recorded statement of Lance, this is going to be admitted because it was done under penalty of perjury. It was done like under an advisement that he could be prosecuted if he didn't tell the truth. So it's considered, a little bit like higher level reliability than just, your neighbor said something the other day and now you're reporting it. But I don't necessarily love it, I'm not going to lie about that. I don't necessarily love it. But I'm used to probable cause being a very low bar to clear because in Washington, we don't have any of these protections, okay? We don't use grand juries like they're allowed, but nobody ever uses them. And then we don't require a preliminary hearing to charge somebody with a felony crime, we don't have the death penalty anymore, but back in the day, capital murder. All that was required was a written affidavit from the prosecutor or the law enforcement officer setting out what they say the facts are, and the judge reads it and decides, does this give me probable cause or not? And if they find probable cause, like that's pretty much it. So there's no like testing of it, no evidentiary basis that really needs to be presented. It's a process. This is what I have, and this is what I'm going to be able to show when we get to the point where we need to be, having this full trial, and kind of all of the panoply of rights and protections and things like that go along with actually convicting somebody of a crime rather than just merely accusing them. Oh. Enjoying myself a little doble choco mocha this morning. So the hotel coffee is terrible. It's so bad. I've stayed in this hotel before. I'm down in Los Angeles, guys. And so I knew the coffee was terrible. So I have this instant coffee that I discovered down in Chile and Patagonia. The Chileans just drink instant coffee. Like in a way, it's kind of disgusting. But on the other hand, that means they have perfected the instant coffee. And so they have this one Nescafe Doble Choco Mocha that I discovered. And it was great for, camping and stuff like that. But when I got back to the US, I couldn't find it anywhere. I'm like, is this just a South American market thing or something like that? I finally found it. I got a whole case of my Doble Choco Mocha. So kind of just a little overexcited about that. So as far as the contempt ruling, God, this light thing is awful. Sorry about that, guys. I'm afraid to move because everything gets strange whenever I do. I am not expecting, as I've said before, any significant development vis-a-vis the contempt. He's not going to drop the death penalty. I'm very happy to kind of lay that card on the line. He's not going to throw the death penalty off based on these comments. I think the real question is just going to be how much does he want to discourage any kinds of comments to the press at all? Because if he's really going to take a hard line, I don't want anybody making comments to the press, then I think what he's likely to do is he's likely to find that these are in violation and this is contempt, but it doesn't warrant a severe sanction. That's one approach he could take. He could find that it's not contemptuous at all, but that's kind of inviting them to test the boundaries of what would constitute contempt, and I'm not sure that he really wants to invite that kind of you know, just flexibility with the gag order. He wants them to view the gag order in kind of the more restrictive way. That's the reason why he adopted it in the first place. So that's kind of where I'm leaning, is what I think the likely outcome is that he would find it's contempt, but perhaps not super willful, perhaps, you know, not egregious, not really warranting anything severe, but just enough to give them a little bit of a slap on the wrist, a little bit of a warning that, you know, hey, you skated a little close to the line this time, and you know, this is your opportunity to your one kind of free shot, so that next time you will be far more cautious and reconsider very, very carefully whether you want to bring your complaints to the press versus litigating your case in court. But we'll see. But we'll see. So just patiently waiting for everything to get started here. I think we are getting pretty close. Any chance of a plea deal? I mean, there's always, I think, a chance of a plea deal. The reason why I think it's difficult for us to know this is just we don't know the behind the scenes stuff. We don't know the full details of the discovery. The stronger the case is, then, you know, the better chance that there is that the defense is going to want to look for some kind of way out. And we don't know if there are things like challenges to the DNA evidence, challenges to the warrants. I'm definitely anticipating challenges to some of the search warrants from what I've seen, particularly the like digital forensics, and because that's in part, it's becoming a little bit routine in cases like this generally, let alone, you know, very high stakes ones like this death penalty case. To argue that these cell phone and like device warrants are overbroad. They just identify these vast categories of evidence that the police are allowed to go and sift through and look for. And so it doesn't really narrowly define what it is that you're, you know, allowed to look at versus what you're not allowed to look at. There's also kind of the technological issue of the process of how they do this anyway. They can't like selectively, they can, but they don't like selectively extract different files, different portions of your computer system or your phone or things like that. Like maybe they're only looking for photographs. They don't just download the photograph, you know, files on your phone. They extract the entire phone. And so there's been some mention in some of the documents about Celebrite. Celebrite is one of the most common tools that is used by law enforcement to do forensic evaluations. And what it is it's a tool that takes the raw data that's obtained from the cell phone extraction and it processes it. They call it parsing. It organizes it and puts it in a format that's readable, that isn't just like digital code, so that it can be navigated by the viewer. And so you get a report out of that. It creates a report, and the person can then just go through and kind of, you know, look at the different things that they want to see. And so you're kind of on the trust me bro system with cell phone, particularly cell phone types of extractions, where you know, the warrant says, okay, here's what you're supposed to look for. But you don't really have any guarantee that that's all they look at. You don't have any guarantee that they didn't go and look through your entire phone, regardless of whether it relates to the warrant or not. So I do anticipate challenges like that. There is, from some of the warrants, it does look like it's possibly a little bit broad, but we'll have to see. So anyway, all of that is just to say that there's a lot that the defense knows that we don't know. And then the other piece of the puzzle, of course, is we don't know if the prosecution is willing to take death off the table. If they're not willing to take death off the table, then there's not necessarily a lot of incentive to plea. In that type of a scenario, there's kind of two ways that it might go. One, if the case is really, really overwhelming and you already know you're going to lose, you might plead without a recommendation to the judge and then just do like a trial or maybe a bench trial or something like that on the penalty phase. And because that gives you the opportunity, then you get to say, I'm remorseful, I've accepted responsibility. Those are things that work in mitigation and suggest that the death penalty shouldn't be imposed. If the case is, not necessarily so strong, or you've been successful at being able to challenge some of the evidence, keep certain things out and stuff like that, then you might have more of an incentive to go to trial. If the state is willing to take the death penalty off the table, you're far more likely to get a plea. So there's just a lot of moving pieces that we don't have the information about to be able to assess. Is there a strong likelihood of this or not a strong likelihood of this? It seems to me that probably they're not willing to take it off the table because you would just kind of expect that that might have already happened, that there would have already been some kind of negotiations along those lines. But we don't know. We don't know those details. We might never know, or we might, only find out after the case is resolved if that kind of thing has happened. Let me check real quick and see anything else. No, we're just waiting for stuff to get started. So why are text messages even allowed to be used as evidence? If I once sent a message, everything I write in this text chain indefinitely is my opinion, theory, and or alleged and never confirmed. Well, it's no different than any other statement, any other hearsay. It still has to follow hearsay rules. The issue is that when it's the defendant's own statements, that's not, it's either not considered hearsay or it's considered an exception to the hearsay rule because it's the statements of a party opponent is one of the exceptions to the hearsay rule. Tyler Robinson doesn't get to offer his own statements. If he says things in the text messages that are exonerating, he doesn't necessarily get to present that because that's his own statements. But if the prosecutor wants to pick out things that are incriminating and present those, they get to do that. And then the opportunity to kind of put all of that in context and, show the other side of the story depends on the applicability of other hearsay exceptions. One of those is the rule of completeness. This is a rule that basically says if one party is only admitting part of a statement, but it needs context to be fairly understood, then the court can allow more of that context to be presented, even if it wouldn't otherwise be an exception to the hearsay rule. But this is just an inherent problem with with witness testimony. People aren't always correct, and sometimes that is for nefarious reasons. Sometimes it is for completely innocent reasons. It's like eyewitness testimony is kind of classic as being like so incredibly unreliable. We have this view of memory as working kind of like a video camera, that just records things and stores it away, and that's not at all how memory works. It's not particularly reliable, and that's especially the case in like traumatic situations or dangerous situations or things like that, where your perception can be distorted and your storage of the memory and your the way that you rewrite the memory when you recall it can be affected as well. But what else do we have? We're imperfect beings, and testimony is an important part of the trial. What people saw, what they observed, what they think they did, and so you can't prove an entire case most of the time without like some people who were there who witnessed it or things like that kind of establishing what actually happened. You can't generally prove a case through nothing but objective cold forensic evidence. Sometimes you can, but just not always. So, you know, this isn't going to get you like your, you know, your free ride to not have your text admitted in court, because this goes to weight, not to admissibility. This just goes to the credibility and how much we should regard your statements as being accurate and truthful and so forth. But that doesn't mean that they're not admissible in the first place. People sometimes want to admit statements that are clearly unreliable by the other person because it makes them look bad. It makes them look guilty. It makes them look sketchy, you know, whatever. And sometimes that might be an issue in the case. It goes to their credibility. If you get on the stand and you testify, and I think you're a lying, you know, piece of trash, then yeah, if I have stuff that might be able to tend to show that you lie and you exaggerate and you make things up, I'm going to try to get that in front of the jury so that they can see you can't be relied on for what you have to say. I have seen a couple of folks in the chat, and I have been really trying to catch up on the whole reckless bin thing, because I know that Judge Graf is involved with that, with the gag order. But I've been, you know, been out of commission, and it's one of those things that's kind of developed a little bit quickly. And I haven't had time to go back and watch my Runkle recap on everything that's happened with that case. But I'm very interested in it just because it's a different perspective on Judge Graf, who so far, I mean, yes, there's a gag order in this case, but it's really quite limited, and it's not that extraordinary. It's just restating what the ethical rules are for the attorneys and making those rules enforceable through contempt in the court instead of having to refer them to the bar and go through bar disciplinary proceedings. So it's not like a super offensive gag order from my perspective. And so because of that, as well as his receptiveness to the cameras in the courtroom, I have seen him largely as you know, pretty strong First Amendment guy. So this gag order in that case, and the order, like there's an order for him to take down his videos and stuff like that. It's a different look, and I haven't seen what is developed with that. So if anybody in the chat has some good updates about what's going on in that, I definitely would love to know. I see, yes, complaints about my sound. I am sorry about that. This is not my normal setting. I am a little bit tech deprived at the moment, so I don't have my nice lav mic that gives me beautiful sound. And sorry, guys, it is what it is. But like I said, we're really not here for me anyway. We're just here to wait for the hearing to get started and see what Judge Graf has to say. What else is going on? Yeah, Runkle has been on top.
Court is now in session.
And so I got some
Calling case
I got a long plane ride. Maybe that's part of my project.
251-403-576. State of Utah versus Tyler James
Looks
Robinson.
like
Counsel,
there's movement
please
in the
enter your
courtroom.
appearances.
They might be
Good
getting
morning, Your
ready to
Honor.
get going.
Chad Grunander, Ryan McBride, Lauren Hunt, Chris Ballard, and Jeff Gray for the state.
I kind of always love seeing
Good morning.
everyone's WebEx set up. Look
Good
at
morning,
Stacy
Your Honor.
Visser. Look at
Kathy
that
Nestor,
spot. That
Richard
is like a
Novak,
great,
Michael Burt, and
that is a
Stacy
great
Visser for
backdrop
Mr.
for the
Robinson.
WebEx.
And if we could please confirm that he could hear us.
I like the white.
Mr.
Mr. Burt
Robinson,
needs
are
to
you
do
with
some
us?
work. Mr. Grunander, these are terrible angles.
They're muted. Let's go ahead and unmute them.
Kathy,
Mr. Robinson, are
terrible
you with
angle.
us?
Yes, Your Honor.
Jeff Gray and Stacy
Good
haven't
morning,
figured
Mr.
out.
Robinson.
They've got the nice lifted camera.
All right. Counsel for the state, and good morning to defense as well. Counsel for the state, I know it's only been a few days, but is there a brief status update regarding discovery?
Yes, Judge. Since Monday, we have received one additional file from the SBI, which has been provided to the defense. So we sit at approximately 100%.
Anything is happening in court yet?
As far as what we've received, we have provided to the defense.
Doesn't look like it. I don't see any mouths
Thank
moving.
you. Turning to defendant's motion for an order to show cause for contempt of court and state's objection to defendant's request to remove the death penalty. The court will read the ruling but omit reading the citations, which will be included in the written ruling, which will be uploaded to the docket later today. The court will begin reading its order.
Ooh, that's a good update. That's a good update. Actions are still limited, so he can't go within 100 yards.
This matter comes
but
before
he
the
can
court on
talk
defendant
again.
Tyler James
That's
Robinson,
good.
motion
That's
for
good.
order to show
Yeah,
cause for
I
contempt
kind
of
of
court.
had it in my
Defendant
mind that
asked this
they were
court to
having
hold
the
Deputy
permanent
Utah
order
County
because
Attorney
what was in
Christopher
place was the
Ballard in
temporary
civil
restraining
contempt
order, which
for
is an ex
allegedly
parte
violating the
process.
court's
It's just one
pretrial
side. There's no
and trial
testing of
publicity
it.
order
It
originally
tends to be a
entered
little
on
bit of a rubber
September
stamp,
16th,
a little bit similar to
2025,
search warrants, but
and amended on
maybe
December
not
15th,
maybe not quite so
2025.
much deference because we're talking
The
about
court has
civilians
thoroughly
versus
reviewed the
police. And of course,
pleadings,
police get all of
affidavits,
the deference from the
declarations, and
court.
exhibits submitted by both parties,
But so yeah,
including
that's what I
defendant's
had in mind
motion,
was happening, and I
the
was very
declaration of
curious
counsel,
about what was
state's
going
opposition,
to be developed.
defendant's
So
reply,
did he get to
the state's
restore his
opposition to
videos then
defendant's
on
request to remove the
YouTube?
death penalty, and
Hear
defendant's
about that?
response thereto. Furthermore, the court has considered the testimony and
Well,
evidence
he can release
presented
his
during the
videos.
evidentiary show
Talk to
cause
the
hearing
press.
held
Good.
on June 12th,
Good.
2026, where Deputy County Attorney Ballard and Utah County Attorney Jeffrey S. Gray testified under oath. Drawing upon Utah statutory law,
I think
the Utah
maybe
Rules
are they
of
waiting for
Professional
Tyler to come in
Conduct,
from the jail or
constitutional
something?
authority, and persuasive precedent from other jurisdictions,
Do seem to
the court
still just
issues
be
this
waiting,
ruling in order. The court has independently determined the facts and applied the law to ascertain whether civil contempt has been proven by
I see
clear
him
and
talking.
convincing
I can't
evidence.
hear him.
This case involves a high-profile capital prosecution of Tyler James Robinson, who was charged with the aggravated murder of Charlie Kirk, a conservative activist, which allegedly occurred at Utah Valley University. Because this case has garnered immense national and international media attention, this court recognized early in the proceedings that pretrial publicity could severely compromise the defendant's right to due process in a fair and impartial jury trial. To protect the fundamental constitutional rights of both defendant and the state, this court, sua sponte, issued a protection order pre-trial and trial publicity on September 16, 2025. The order explicitly stated that lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. The order further incorporated Rule 3.6A's prohibition against making an extrajudicial statement that the lawyer knows or should reasonably know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Following a motion by the state for clarification regarding the term witness, the court issued an amended order on December 15, 2025, clarifying the scope of the attorney's duties to instruct their respective teams. The present controversy emerged following a public filing by the defense on March 27, 2026. Defendant filed a motion to vacate or continue the preliminary hearing. In that motion, defense counsel characterized a forensic summary report from the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, by stating that the ATF was unable to identify the bullet recovered at the autopsy to the rifle allegedly tied to Mr. Robinson. The actual ATF report concluded that the bullet jacket fragment could not be identified or excluded as having been fired from Exhibit 1 rifle, and that the results of the comparison was inconclusive. The defendant's framing of the ATF report in an unsealed public court filing promptly generated substantial media coverage. On March 30th, 2026, the Daily Mail published an article with the headline, "Bullet used to kill Charlie Kirk did not match rifle allegedly used by suspect Tyler Robinson, new court filing claims." Other news outlets and social media commentators rapidly echoed this narrative, characterizing the ATF report as exculpatory, a bombshell that exonerates Robinson, and evidence that the state's case possessed a fundamental problem. Faced with a rapidly expanding public narrative that falsely suggested that the ATF had affirmatively excluded the defendant's rifle as the murder weapon, Deputy Utah County Attorney Christopher Ballard engaged in several communications with media outlets, including TMZ, USA Today, PolitiFact, and Fox News between March 31st and April 2nd, 2026. In these communications, Mr. Ballard sought to correct the record regarding the definition of an inconclusive ballistics test. However, during these interviews, Mr. Ballard also provided statements regarding the overall strength of the state's evidence, asserting that the prosecution had ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder and that the state believed it would be able to overcome his presumption of innocence. On April 15, 2026, defendant filed the instant motion for an order to show cause for contempt of court, seeking to hold Utah County Attorney Jeffrey S. Gray and Deputy County Attorney Christopher Ballard in civil contempt. Defendant concurrently sought an order compelling discovery related to internal communications of the Utah County Attorney's Office, referred to as UCAO. The state filed its opposition on April 30th, 2026, arguing that Mr. Ballard's statements were protected under the safe harbor provision of URPC 3.6C, which permits a lawyer to make statements necessary to mitigate substantial undue prejudice generated by recent publicity not initiated by the lawyer. The state argued that the defendant's misleading public filing necessitated the response. Defendant filed a reply on May 7th, 2026. On June 1st, 2026, this court issued a ruling and order granting the motion for an order to show cause, determining that the defendant had made a sufficient preliminary showing under Utah Code 78B-6-301 sub 5 to warrant an evidentiary hearing. The court concurrently denied the defendant's request to compel discovery of the UCAO's internal communications. The court held an evidentiary show cause hearing on June 12, 2026. During the hearing, the court took testimony from Mr. Ballard and Mr. Gray, both who were subjected to direct and cross-examination. Following the hearing, the state filed an unsolicited objection to defendant's request to remove the death penalty as a sanction, to which the defendant filed a response on June 18, 2026. Having considered the pleadings, the exhibits, and the sworn testimony presented at the June 12, 2026 hearing, the court makes the following findings of fact by clear and convincing evidence. On September 16, 2025, this court issued a valid lawful protection order pre-trial and trial publicity. The order explicitly required all participating lawyers to abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct and prohibited extrajudicial statements possessing a substantial likelihood of materially prejudicing the adjudicative proceedings. The order was subsequently clarified on December 15, 2025. Deputy County Attorney Christopher Ballard had actual notice of the publicity order. Mr. Ballard personally signed the state's November 6, 2025 motion to amend or clarify the court's pretrial and trial publicity order. During his testimony on June 12, 2026, Mr. Ballard acknowledged his familiarity with the order and his ethical obligations under URPC 3.6. At all times relevant to this inquiry, Mr. Ballard possessed unhindered ability to comply with the publicity order. There were no physical or legal impediments that prevented him from adhering to the court's directives. On March 27, 2026, defense counsel filed a motion to continue, containing the assertion that the ATF was unable to identify the bullet recovered at the autopsy to the rifle allegedly tied to Mr. Robinson. The actual ATF report concluded that the bullet jacket fragment could not be identified or excluded as having been fired from the subject rifle, rendering the result inconclusive. Relying upon the defense's filing, media outlets generated highly sensationalized and factually inaccurate headlines. The Daily Mail declared the bullet did not match the rifle. Commentators described the ATF report as a bombshell that exonerated the defendant. Between March 31st and April 2nd, Mr. Ballard engaged in extrajudicial communications with multiple media entities. On March 31st, 2026, Mr. Ballard was quoted by TMZ stating, "Generally, when a bullet fragment analysis comes back as inconclusive, that means the fragment did not contain enough detail for the examiner to say one way or the other. There's just not enough there to determine whether the bullet was fired by a particular firearm. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing, and we will present all that evidence at trial." Mr. Ballard further stated, "He is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence." On March 31st and April 2nd, 2026, Mr. Ballard provided statements to USA Today and PolitifaFact, strictly limiting his commentary to the mechanical and forensic definition of an inconclusive ballistics test, noting that ethical rules prohibit him from speaking publicly about forensic testing and the test results, but clarifying that inconclusive means only that the fragment did not contain enough detail for the examiner to determine whether the characteristics on the fragment were consistent with having been fired by a particular firearm. Having observed the demeanor and testimony of Mr. Ballard during the evidentiary hearing, the court finds that Mr. Ballard testified credibly regarding his subjective intent. The court finds that Mr. Ballard did not engage with the media out of a malicious desire to flout this court's authority or to intentionally taint the jury pool. Mr. Ballard testified that he believed his statements were necessary to respond to public reporting concerning the ATF report. In Utah, contempt proceedings are governed simultaneously by common law principles and the statutory framework outlined in Utah Code 78B-6-301. Section 78B-6-301 sub 5 expressly dictates that disobedience of any lawful judgment, order, or process of the court constitutes a contempt of the authority of the court. To hold a party in civil contempt for violating a court order, the moving party must prove three common law elements by clear and convincing evidence. 1, the person cited for contempt knew what was required by the order. 2, the person had the ability to comply with the order. And 3, the person intentionally failed or refused to do so. Utah law requires proof by clear and convincing evidence that the alleged contemptor knew of the order, possessed the ability to comply, and intentionally committed the acts constituting the violation. Von Hake remains controlling Utah precedent. Because the court concludes those elements are satisfied under existing Utah law, it is unnecessary to determine whether the objective good faith standard discussed in Taggart v. Lorenzen would independently alter Utah civil contempt jurisprudence. Even assuming Taggart provides persuasive guidance, the result would be the same because the challenge statements exceeded the objective limitations contained in Rule 3.6c. Contempt is categorized as either direct or indirect based on where the conduct occurred. Direct contempt occurs in the immediate presence of the court and may be punished summarily. Utah Code 78B-6-302 sub 1. Indirect or constructive contempt occurs outside the presence of the court and triggers robust due process protections. Because Mr. Ballard's extrajudicial statements occurred outside the immediate view and the presence of the court, this constitutes an allegation of indirect contempt. Due process for indirect civil contempt requires notice, an opportunity to be heard, and presentation of the charges via an affidavit or sworn statement detailing the facts constituting the contempt. The court must issue an order to show cause and hold an evidentiary hearing where the accused may present and answer and examine witnesses. Here, the court finds that all procedural due process requirements have been satisfied. Defendant submitted an affidavit of counsel. The court issued an order to show cause, and the court convened a full evidentiary hearing on June 12, 2026, at which the accused testified and presented argument. A critical distinction must be drawn between civil and criminal contempt, as the classification dictates the available sanctions. As the Utah Supreme Court articulated in Von Hake, the distinguishing factor is whether the sanction is conditional or fixed. A contempt order is criminal if the punishment is fixed, unconditional, and purely punitive, designed to vindicate the authority of the court. Conversely, a contempt order is civil if the sanction is remedial, designed to either compensate the aggrieved party for injuries resulting from the noncompliance or to coerce further compliance through a conditional penalty. Because the defendant brought this motion seeking remedial sanctions to cure alleged prejudice to his fair trial rights, the court evaluates this strictly as a civil contempt proceeding. This court's publicity order expressly incorporated Rule 3.6 of the Utah Rules of Professional Conduct. Rule 3.6 reflects the constitutional accommodations recognized in Gentile versus State Bar of Nevada, under which an attorney participating in pending litigation may be subject to narrowly tailored speech restrictions when necessary to protect the integrity of an adjudicated proceeding. This rule therefore protects both the attorney's First Amendment interests and the criminal defendant's Sixth Amendment right to trial before an impartial jury. Neither constitutional interest is absolute. Each must be reconciled through a careful application of the rule's objective standards. Rule 3.6a sets forth a general prohibition. A lawyer shall not make an extrajudicial statement that they know or reasonably should know will be disseminated publicly and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. Comment to Rule 3.6 explicitly enumerates subjects that are more likely than not to have a material prejudicial effect, particularly in a criminal proceeding. These prohibited subjects include the performance or results of any examination or test or the nature of physical evidence, any opinion as to the guilt or innocence of a defendant, the fact that the defendant has been charged, unless accompanied by a statement explaining that the charge is merely an accusation and the defendant is presumed innocent. However, the rule contains critical exceptions. Rule 3.6b permits the lawyer to state information contained in a public record without elaboration. Furthermore, Rule 3.6c provides a safe harbor or right of a reply. A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Crucially, any response under 3.6c shall be limited to such information as is necessary to mitigate the recent adverse publicity. The Utah Supreme Court recently addressed the ethical boundaries of prosecutorial speech in a capital case in the matter of the discipline of David O. Levitt. In Levitt, a county attorney held a press conference announcing his decision to seek the death penalty and stated that the state's key witness was credible based on a lot of evidence that the jury will never hear, and that he possessed evidence strengthening his belief that the defendant committed the murders. The Utah Supreme Court held that a prosecutor's opinion of guilt is particularly likely to create prejudice, given that his or her words carry the authority of the government and are especially persuasive in the public's eye. The court disciplined the prosecutor, recognizing while transparency is a legitimate objective, prosecutors possess a heightened ethical duty to ensure that justice is done, which includes respecting the constitutional rights of the accused, like the presumption of innocence. Civil contempt is an extraordinary remedy. Because contempt implicates both judicial authority and competing constitutional interests, the court defines its decision to narrow conduct presented by this record. This court possesses the inherent authority to regulate the conduct of attorneys appearing before it and the statutory authority to punish disobedience of its lawful order under Utah Code 78B-6-301. As noted by the Utah Supreme Court, courts must maintain and protect the integrity and dignity of the profession. A judge presiding over a high-profile capital case bears an affirmative constitutional duty under the 6th and 14th Amendments to take preventative measures against prejudicial pretrial publicity that could taint the jury pool. The enforcement of the September 16, 2025 publicity order is squarely within this court's jurisdiction and within the court's inherent and statutory authority. To hold a party in contempt, the order violated must be clear and unambiguous. The court finds that the publicity order was exceptionally clear. It did not rely on vague prohibitions. Instead, it explicitly incorporated the exact text and framework of Rule 3.6 of the Utah Rules of Professional Conduct. It directed the attorneys to abide strictly by its parameters. The incorporation of standard, universally understood rules of professional ethics renders this order unambiguous. The court finds that Deputy County Attorney Ballard had actual notice and knowledge of the order. The record reflects that Mr. Ballard signed a motion seeking to clarify the order in November 2025. He never contested his awareness of the order or his obligations under Rule 3.6 during the evidentiary hearing. The first element of civil contempt, knowledge of the order, is established beyond doubt. The defendant alleged Mr. Ballard's statements to the press between March 31st and April 2nd constitute multiple distinct violations of the publicity order. The court analyzes these statements by categorizing them in two distinct thematic areas. First, statements clarifying the ATF ballistics report, and second, statements regarding the overall strength of the state's case and presumption of innocence. Allegation 1, statements clarifying the ATF ballistics report. The conduct. Mr. Ballard sent written emails to PoliticoFact and gave statements to USA Today and TMZ explaining the meaning of an inconclusive ballistics test. Specifically, he stated, when the results of a bullet fragment analysis come back as inconclusive, that does not mean that the rifle did not fire the bullet. There just aren't enough marks on the fragment to make a conclusion one way or the other. Supporting evidence, quotes published in USA Today, PoliticoFact, and TMZ. Contrary evidence and defenses. The state argues these statements were expressly permitted by Rule 3.6c as necessary to protect the state from substantial undue prejudicial effect of recent publicity that the prosecution did not initiate. The defense initiated the media frenzy by stating in a public filing that the ATF was unable to identify the bullet to the rifle. The media twisted this phrase to mean the bullet did not match. Factual and credibility findings. The court finds that the defense's characterization in its March 27th motion to continue was technically accurate, but highly prone to misinterpretation. By framing the results as unable to identify, the defense neglected to include the ATF's concurrent finding that the bullet also could not be excluded. The media seized on this omission, generating headlines that materially overstated the forensic conclusions, stating the bullet did not match the rifle. The court finds Mr. Ballard testified credibly that he viewed this media narrative as highly prejudicial to the state. Legal analysis. Rule 3.6c permits a lawyer to make a statement that a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer. A false media narrative asserting that the murder weapon has been definitively forensically excluded constitutes substantial undue prejudice to the prosecution. Mr. Ballard's statements explaining the forensic mechanical definition of an inconclusive test were narrowly tailored to mitigate this specific prejudice. While comment 5 generally prohibits discussing the results of the test, the safe harbor of Rule 3.6c authorizes otherwise restrictive responsive statements only to the extent reasonably necessary to mitigate the recent prejudicial publicity. Conclusions on allegation 1. The court finds Mr. Ballard's statements clarifying that the ATF's inconclusive findings were protected by the safe harbor provision of URPC 3.6c. These statements do not constitute a violation of the publicity order. Contempt is not proven regarding these specific statements. Allegation 2, the statements opining on the strength of the evidence and guilt. The conduct. Beyond merely correcting the ballistics record, Mr. Ballard provided the following statement to TMZ. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing. And then we will present all of that evidence at the trial. He further stated, he is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence. Supporting evidence. The published TMZ article dated March 31st, 2026. The state does not deny these statements were made. Contrary evidence and defenses. The state relies on State v. Wright, a Kansas case, arguing that a prosecutor's general statement that his job is to bring cases he believes he can prove beyond reasonable doubt does not express an improper opinion on guilt. The state argues that merely expressing confidence that it has enough evidence to carry its burden tells the public nothing more than what the existence of the prosecution already proclaims. Factual and credibility findings. The court finds that Mr. Ballard subjectively believed he was operating within the bounds of Rule 3.6. However, the court finds that his subjective belief regarding these statements was objectively unreasonable. Legal analysis. Rule 3.6c strictly dictates that any responsive statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. The adverse publicity here concerned one specific piece of physical evidence, a bullet fragment. The court does not conclude that Rule 3.6c prohibited all public response. To the contrary, Rule 3.6c expressly recognizes that in limited circumstances, counsel may respond to recent publicity not initiated by the lawyer or lawyer's client. The question is not, therefore, whether Mr. Ballard could respond, but whether a reasonable lawyer would have believed additional statements concerning the overall strength of the prosecution's evidence were necessary to mitigate the specific prejudice created by the inaccurate reporting concerning the ATF examination. The court applies an objective standard. The subjective good faith of counsel is relevant to credibility, but does not determine whether Rule 3.6c's limitation was satisfied. The state's reliance on State v. Wright is misplaced. Wright is distinguishable because it addressed statements made during voir dire rather than extrajudicial statements governed by Rule 3.6. As Utah Supreme Court recently reiterated in Levitt, when an elected prosecutor or their deputy makes public declarations regarding the strength of evidence or their belief in ultimate outcome of the trial, those words carry particular weight and authority of the government. Stating that the prosecution has ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder reasonably communicated to the public the prosecutor's assessment of the defendant's guilt, that the defendant was guilty. This directly violates comment 5, Roman numeral 4 of Rule 3.6, which prohibits expressing any opinion as to the guilt or innocence of a defendant. While Mr. Ballard offered a cursory nod to the presumption of innocence, he immediately undercut it by publicly broadcasting his belief that the state will overcome his presumption of innocence. These statements were not reasonably necessary under Rule 3.6c to mitigate the confusion surrounding the ATF report. Rather, those additional public statements possessed a substantial likelihood of materially prejudicing the proceedings by communicating the prosecutor's assessment of the defendant's guilt.
So he's in contempt.
Conclusion on allegation 2. The court finds that the statements to TMZ regarding ample evidence in overcoming the presumption of innocence violated Rule 3.6a and were not protected by Rule 3.6c safe harbor. Because Mr. Ballard knew of the order, possessed the ability to comply, and intentionally made the volitional statements in question, the elements of civil contempt are proven by clear and convincing evidence. The state and the UCAO possesses vital First Amendment interests in communicating with their constituents and defending the integrity of their investigation against false media narratives. Rule 3.6c accommodated that right by allowing Mr. Ballard to correct the inaccurate ballistics narrative. However, the defendant's Sixth Amendment right to a fair trial places a constitutional ceiling on prosecutorial speech. As the United States Court held in Gentile, the lawyer's right to free speech in a pending case is circumscribed because lawyer statements are likely to be received as especially authoritative. In capital cases where life is at stake, the court concludes that defendant's Sixth Amendment interests predominant under these facts. The court's ruling is not based on disagreement with the prosecutor's viewpoint, nor on the mere fact that the challenge statements were made publicly. Rather, the court enforces a pre-existing publicity order that incorporated Rule 3.6, applied equally to all participating counsel, and governed attorney conduct in a pending capital prosecution. The contempt finding rests on the conclusion that the identified statements exceeded the objective limits of Rule 3.6c, not on the content of the state's position or the court's assessment of the merits of the prosecution. The remedial measures ordered are directed to preserving jury impartiality and future compliance with the court's order. Thus, the application of civil contempt sanctions here does not offend the First Amendment. For the reasons stated above, the court independently determines that the movement has proven by clear and convincing evidence that Deputy Utah County Attorney Christopher Ballard is in civil contempt of the September 16, 2025 and December 15, 2025 publicity orders. The court emphasizes this ruling does not address the merits of the criminal charges, the credibility of anticipated witnesses, or the ultimate guilt or innocence of defendant. Its sole purpose is enforcement of a narrowly tailored publicity order governing attorney conduct. A reasonable attorney invoking Rule 3.6c may respond only to the specific prejudice requiring correction. The prejudice identified here concerned the public misunderstanding of the ATF's inconclusive forensic finding. Once that misunderstanding had been fully addressed, further commentary concerning the overall strength of the prosecution's evidence did not materially assist in correcting specific misimpressions. Rather, those additional statements induced a separate subject, the prosecutor's assessment of the ultimate merits, which Rule 3.6 independently regulates. Conclusions of law. First, the pretrial and trial publicity order entered on September 16, 2025 and amended on December 15, 2025 was a valid, clear, and unambiguous lawful order of this court. 2, Deputy County Attorney Christopher Ballard had actual notice of the order, knowledge of its contents, and the unhindered ability to comply with its directives. 3, although Rule 3.6c permitted limited responsive statements explaining the ATF report, Mr. Ballard's additional statements concerning the strength of the state's evidence and anticipated ability to overcome the presumption of innocence exceeded the scope of that exception and violated the court's publicity order. 4, Mr. Ballard intentionally and volitionally made these extrajudicial statements, fulfilling the required elements of civil contempt pursuant to Utah Code 78B-6-301, sub 5, and Von Hake v. Thomas. Order and sanction. Having found Mr. Ballard in civil contempt, the court turns to the imposition of sanctions. The defendant argues that the appropriate sanction to remedy this prejudice is to strike the state's notice of intent to seek the death penalty. The court declines to adopt this requested remedy.
We knew that.
As the state correctly argues in its objection, striking a capital enhancement or reducing the charge is not a remedial civil sanction. It is a fixed, absolute, and purely punitive sanction. Such an act would cross the threshold into criminal contempt sanctions and would also risk an improper judicial intrusion into the executive branch's prosecutorial discretion. Civil contempt sanctions must be remedial, tailored to cure the prejudice caused by the violation, or designed to coerce future compliance. The court finds that striking the death penalty is grossly disproportionate to the misconduct and legally unavailable in this civil contempt framework. Before imposing sanctions, the court considered whether a mere finding of violations without remedial measures would adequately protect the integrity of future proceedings. The court concludes it would not. At the same time, the court rejects punitive sanctions that would intrude upon prosecutorial charging authority or materially alter the underlying criminal proceedings. The selected remedy addresses only the potential effects of the publicity on jury selection and future compliance with the court's order. Accordingly, the court concludes that relief ordered constitutes the least intrusive means reasonably necessary to remedy the identified prejudice. However, the violation requires a meaningful remedy to compensate the aggrieved party and protect the integrity of the impending trial. The court draws guidance from the remedies deployed by the district court in Leavitt to cure jury pool taint. Therefore, it is hereby ordered. The defendant's motion for an order to show cause for contempt of court is granted insofar as the court finds Deputy County Attorney Christopher Ballard in civil contempt. Enlargement of jury veneer to directly remedy the potential taint introduced into the Utah County jury pool by Mr. Ballard's statements regarding the strength of the evidence. The court will consider expanded voir dire procedures, additional jury questionnaires, expanded jury summons, or other remedial measures as necessary after consultation with the parties. Attorney's fees. Because this civil contempt proceeding was necessitated by Mr. Ballard's violation, the court shall compensate the defendant for the reasonable attorney's fees and costs incurred in the filing, drafting, and litigating of the motion for order to show cause and the evidentiary hearing. Defense counsel is ordered to submit a detailed affidavit of costs and fees within 14 days of the order of this court. The state shall have 7 days thereafter to file any objections to the reasonableness of the requested fees. Future compliance. The court reaffirms the existing publicity order. Any future violation may result in additional contempt proceedings and sanctions authorized by the law. Courts depend upon public confidence that criminal prosecutions will be decided upon evidence presented in open court rather than public advocacy outside of it. This order should not be understood as discouraging legitimate public communication authorized by Rule 3.6. Rather, it reflects the court's obligation to enforce a previously entered order equally against all counsel and to preserve the fairness of the proceedings for both the defendant and the state. And this concludes the ruling of the court. Again, this will be uploaded to the docket before the end of the day.
Well, I called that
Counsel,
one.
let's move on.
Pat me on the head.
Turning to defendant's oppositions to EMC order for the preliminary hearing. The court will issue a written ruling by midweek next week. The court recognizes that both parties are actively preparing for the preliminary hearing scheduled to begin on July 6th. Given the time and attention required for that preparation, the court does not believe an oral ruling on the motion is necessary. The written ruling will be uploaded to the docket and parties will receive notice once the court has issued its decision. Turning to the upcoming preliminary hearing. The court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of the duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the fourth floor. Portable electronic devices include any device that can record or transmit data, images, or sounds, or access the internet, including a pager, laptop, notebook, personal computer, handheld PC, PDA, audio or video recorder, wireless device, cellular telephone, electronic glasses, or an electronic calendar. This prohibition does not apply to legal counsel and support staff for the defense or the state in this matter, or the equipment permitted under any controlling electronic media coverage order. In addition, every person who will be in attendance will be afforded the dignity and respect due to them, and pursuant to the September 24th, 2025 standing decorum order, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, and shall not otherwise make any gestures during the hearing. Spectators shall not wear or display pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case or the status of this case as a capital offense. Members of the media and public will be permitted in the courtroom subject to available seating. A limited number of seats will be reserved for each group and will be made available on a first-come, first-served basis. The court respectfully asks all persons seeking admission to conduct themselves in an orderly and respectful manner while court staff and security personnel carry out their responsibilities, including security screening and the assignment of wristbands for entry into the hearing. Counsel, does either party require the benefit of the record?
Yes, Judge. Mr. Grunander for the state. A question. I know this order does not apply to legal counsel for the state or the defense or our staff that are there assisting us, but will the court permit counsel for the victim's representative to keep his phone on his person?
To defense, any input?
We have no objection to that, Your Honor.
All right. Mr. Grunander, based off no objection and finding it is in the interest of what is permissible, I will grant that request, and I appreciate that clarification.
Thank you. And then I have one other item that goes outside of this particular order, Judge, if you're ready to hear it.
Yes.
There may be some sensitive information that is presented during the preliminary hearing. And the state would like to be able to alert the court before that happens to allow for members of the victim's family to exit the courtroom prior to it being presented in the court. We anticipate turning the monitors away from the gallery, but there will be some audio that could be sensitive nonetheless. So we would like to inform the court that we would like to alert Your Honor before that happens to allow for them to exit the courtroom. And then once that is presented, allow for them to return to the courtroom. That would be the state's request.
Thank you, Mr. Grunander. To defense, did you want to respond?
It doesn't seem like a response is necessary from us, Your Honor. We think that's up to the court, how the court wants to handle that.
Thank you. Pursuant to Article 1, Section 28 of the Utah Constitution and subsequent Utah law, victims are entitled to be treated with dignity and respect. And I find that this request falls squarely within that, and I will grant that request. Counsel, just as soon as you can, as soon as it is upcoming, feel free to alert the court, and the court will take a brief recess to allow the victim representatives and to to make that decision. And if they wish to leave the courtroom, they may do so. And then after that evidence has been presented, they will be allowed to return. So we'll take a recess after that sensitive material, as you've defined, is presented. And just if you could alert the court, so a brief recess could be taken to allow them to come in to ensure that they are able to be fully present for as much as a preliminary hearing that they choose to participate in.
Perfect. Thank you, Judge.
All right, turning to defense, do you require the benefit of the record or wish to bring up any additional items?
Your Honor, Michael Burt for Mr. Robinson.
All right, Mr. Burt.
Judge, at the last hearing, I indicated to the court that we would be seeking a ruling from the court prior to the hearing concerning some expert witnesses that the defense had subpoenaed from out of state. And after discussions with the state, it appears that the state has no objection to the presentation of those witnesses. We have pared down the number of witnesses that will be called, and currently there will just be 3 witnesses who will be called, 3 expert witnesses. The other witnesses we will be handling by way of a stipulation.
Thank you, Mr. Burt. To the state, any input?
That is accurate, Judge. We are working with defense counsel with respect to some stipulations. We have decided not to object to the presentation of these defense experts. With that said, during the hearing, there may be objections that are raised if the questioning or answers seeking to be addressed goes outside the scope of the preliminary hearing or borders on a 702 hearing. So we want to preserve those objections.
All right, thank you, Mr. Grunander. Ms. Nestor, anything further? Or Mr. Burt? And again, I appreciate all parties bringing these issues up now just to remove any misunderstandings.
Nothing further for me, Your Honor.
Nothing from the
The
state.
defense has nothing else, Your Honor. Thank you.
All right. Lastly, the court wishes to inform the parties that as it relates to exhibits being presented in regards to whether it's published or not in open court, or if copies of the exhibits are given to the public or news media, I will take that up on a issue by issue basis. So per exhibit, all parties will be entitled to object, not object, stipulate. So we have a clear record and the court doesn't make a blanket ruling, as each individual exhibit is its own exhibit. And the court wants to apply the appropriate analysis to each exhibit presented in court, as the court does not know and cannot anticipate what exhibits will be presented, even though there has been indication what will be presented. It doesn't become relevant until it's actually moved into evidence. And so that's why the court is not issuing a blanket ruling, wants to see where it's coming in, all the factors that govern if it should or should not be admitted and should or should not be published to the court, to the parties, or to the public. And so I just wanted to give that clarification because perhaps in the back of your mind, you were wondering. All right, counsel, I also wish to remind you the purpose of the preliminary hearing and the standard, and I offer that simply as a reminder as you're presenting your evidence. That is a standard that the court is holding to, and just wanted to provide that for guidance to all parties. Unless there is anything else, we will reconvene on July 6th, 2026 at 9 a.m. for the preliminary hearing in this matter. Court is adjourned.
Thank you, Your Honor.
Well, pretty much what we predicted there. Found him in contempt, but no real meaningful consequence. There, what? How do you remediate it? Remediate it at this point in time. You can't like go back to the press and be like, never mind, pretend I didn't say that. It's not effective. Plus, it just draws attention to the stuff that you said in the first place. So it's going to go to jury selection, and the remedial measure will be things like, you know, they can ask, they'll include in the jury questionnaire specific questions about, like, did you hear anything that Mr. Ballard said about the case, or something like that. Well, so sorry about the top. I could not hear what was happening, and apparently the webinar had muted the sound for me, but not for you. But it doesn't seem like there was anything real substantive that was happening while I was busy talking over the judge. I'm sure they did their introductions and all that stuff. So this was a characteristically long ruling. As you know, I am a Judge Graf fan. I really am. I like him. I like how he thinks. I like how he is just very organized and systematic and structured in how he puts his decisions together. But that said, he does have a tendency to be quite repetitive. He says the same thing many, many times over the course of his ruling. And so this one was really no exception. He started by, of course, just giving us the background, the timeline. Here's what happened. The gag order was issued, recognizing that there's substantial international media interest in the case and the publicity could be prejudicial to the fair trial. Then we had the March 27 defense filing, which stated the ATF report, the analysis, could not identify the bullet that was recovered at the autopsy of Charlie Kirk to the rifle that was recovered at the scene. In fact, the report said they couldn't ID or exclude the bullet, and the result was inconclusive. But nevertheless, the Daily Mail, pardon me guys, cover your ears if you're sensitive. Fuck the Daily Mail, okay? Fuck the Daily Mail. Daily Mail fucking sucks. God, they're the worst. It's probably an Alison Boshoff article. No, I know it wasn't, but might as well have been. They published the article that characterized this as exonerating, as a bombshell, that it completely undermined the state's case, meant they weren't going to be able to go forward with the prosecution and so forth. So based on that, Mr. Ballard had these various communications to the media outlets, which he is arguing is protected under the safe harbor provision of the RPC, the right to respond to prejudicial pretrial publicity that was not initiated by that lawyer or that lawyer's client. But he also exceeded. He made statements that clarified. He sought to correct the record as far as the definition of an inconclusive test, but he also exceeded that and made statements about the strength of the state's case. So that led us to these proceedings, this motion, the testimony that was taken, the OSC that was held, and so forth. So we have the findings. The findings, he finds that his pretrial protective order is valid and clear. Of course he does. He doesn't see any problem with the protective order. I continue to find the protective order a little bit challenging and confusing, and I don't think I'm alone in this because there continues to be like persistent questions about who is actually covered by this order. Does this affect witnesses or not? In its plain terms, it doesn't affect witnesses, but it also kind of characterizes the witnesses as part of the teams, and the teams are being subject to the order. So it's all like it's all less than clear in that respect from my perspective, but I don't think that particularly matters in this instance because it is quite clear that the prosecutors are covered by the protective order. And then he did that order clarifying, which like really didn't clarify. He's like, yes, the witnesses are part of the teams, but only the attorneys are going to be sanctioned if there are problems. And so it's like, so is the prosecutor the keeper of the witnesses and like is supposed to control what like maybe lay people have to say about the case and stuff like that? It's a little messy from my perspective. But he finds that, of course, Mr. Ballard had personal notice of the order. In fact, he was the one who signed the motion to clarify the protective order. And he has not, testified to any lack of knowledge or ability to comply with it. He does find that the media outlets, in response to the defense filing, they generated sensationalized and inaccurate headlines and stories. What else is new, especially from the fucking Daily Mail? And so in response, Mr. Ballard engaged in these extrajudicial communications with a variety of news outlets. So first he finds that Mr. Ballard did not engage with the media with malicious intent. He was not trying to taint the jury pool. He was not trying to flout the court's order. He was trying to stay within its limits. He just failed to do that. So he then reviews the elements that have to be required, have to be proven by clear and convincing evidence to establish contempt. To find somebody in contempt, there has to be showing that they knew of the order, they had the ability to comply with it, and they intentionally refused or failed to do so. So he finds that some of the challenge statements exceeded the limitations of the rules of professional conduct, 3.6 and the safe harbor limitation. So first he talks about the difference between direct and indirect contempt. Direct is what happens in court in front of the judge. If you, somebody shows up during the preliminary hearing and causes a scene in the gallery, while the hearing is going on, that is directly in the presence of the judge. He doesn't have to give you any due process. He's seeing for himself. He can summarily punish that. And I totally, expect that he would, and that's kind of commonplace that people would get removed from the courtroom, potentially, charged and stuff like that. But when it doesn't happen in the court's immediate presence, that is indirect contempt. And so since he doesn't have the personal knowledge, and also it's not part of his general authority to regulate what is going on in the courtroom, there's due process that's associated with that. So notice, opportunity to be heard, affidavit, presenting the basis for the charges, and so forth. He finds that all of those procedural due process protections were provided. He then moves on to clarifying the difference between civil contempt and criminal contempt. Criminal contempt is punishment. It is there to deter you from doing it again in the future. Civil contempt is remedial. It's there to fix a problem that was created. It's not to slap you on the wrist or something like that. It's just to correct whatever harm has resulted from the violation of the order. And so one way to tell if you're dealing with civil contempt or criminal contempt is whether the penalty that you're facing is conditional. Like, is it something that you can purge your contempt, you can, like undo the consequences in a way that will fix it? Or is it a sanction that is, that's fixed, that's like determined, like this is going to happen, you are going to jail no matter what. And so the difference is kind of illustrated by, what always comes to my mind as an example in these types of situations are the cases against, oh, and now I'm spacing her name, the reporter who went to jail for the Clintons for not revealing her source. I think during Watergate or something like that. She spent a significant length of time in jail. I want to say it was like 180 days. And so what happens in those situations? There's no reporter shield under federal law. So if you're in federal court and somebody subpoenas a reporter in and puts them on the stand and asks them to reveal their source, and they say, no, I'm not going to do that. What often happens is this civil contempt measure where the judge basically says, all right, well then you're going to sit in jail until you decide you're going to go ahead and give up your source. And in that particular case, she sat in jail, pretty much indefinitely, because she refused to purge her contempt, complying with the court's order to answer the question, and therefore, she sat. So that's like the principled, journalist thing to do. But the counter example then would be, if the reporter were just sentenced, you didn't comply with the order. You refuse to testify, that was contempt of court, and they go through a criminal process, and as a result of that, you are just going to serve a month in jail no matter what. That's criminal contempt. That is, that's a fixed penalty. It has nothing to do with whether you agree to follow the court's order or not. It's just there to punish you for saying no in the first place. So this is a civil contempt process. This is not criminal. Nobody is charging Mr. Ballard with criminal contempt, which is like, of course, the prosecutor is not charging the prosecutor with criminal contempt, like, duh. But either way, it's civil. It's geared towards remediating the problems that were potentially created by these statements. He finds that the order, was clear. It explicitly incorporated the RPC 3.6, the rules on pretrial publicity. There's Supreme Court case law that the Nevada versus Gentile case that he referred to, very well-known U.S. Supreme Court case, where it finds that the First Amendment does tolerate limited speech restrictions on attorneys who are involved in the particular proceeding. And it's because their statements are likely to, kind of like he was describing with the prosecutors, they're likely to carry significant weight because people expect you have inside information. If you're one of the lawyers in the case, you know things that I don't. So your opinion about it, or just your representations about it, are going to have more influence than some rando who's not involved having comments about it. And it also relates to the lawyer's duties as officers of the court to maintain the integrity of the process and so forth. So based on the RPC 3.6, there are certain prohibited statements that you are not allowed to make. You are not allowed to talk about tests, performance of scientific tests and examinations and the results. You're not allowed to offer opinions on guilt. You are not allowed to talk about somebody being charged unless you specify specifically that the defendant is presumed innocent. You are allowed to talk about information that is already in the public record, but you must do so without elaboration. You don't get to editorialize about what's in the public record. And then there is, of course, this safe harbor provision, which affects the right of reply. So when the prejudicial media is out there, you do have a right to reply. However, it's quite limited. You got to tailor it and be cautious. So we did point to the Levitt case. We looked at the Levitt case before. The statements in that one were so bad. Like they were so bad. No real question in my mind that this was not on that level. I mean, yeah, the guy's like, oh, we totally know he's guilty because we have all this inside information that you'll never know anything about. I mean, it's like possibly one of the worst things you could say. In terms of like capitalizing on the whole reason you have the speech restrictions in the first place, right? That you're gonna carry more weight because you're kind of understood to have inside information. He's just like making that explicit. Yeah, we do. So that's why we're going forward with this prosecution. And it's also particularly bad when prosecutors make statements like this because they have a heightened duty to ensure that justice is being done in the court process and in their conduct. Don't always live up to that. But I mean, so far, I have to say I haven't seen conduct by this particular prosecuting attorney's office that seems, exceptionally bad. Like I've dealt with far worse prosecutors than these. Far worse. Oh my lord, keep yourselves out of Grant County, Washington. The court finds that contempt is an extraordinary remedy, but he also has a duty to maintain the dignity and integrity of the process, as well as a responsibility under the Sixth Amendment to take measures to protect against prejudicial pretrial publicity. And so that's what he did with his clear and unambiguous gag order. So it's never contested that Ballard knew what the order said or that it applied to him and so forth, what it required. So then he categorizes the violations that the defense has asserted into two categories. We have first the statements that are tailored towards clarifying the results of the ATF examinations, and then statements that offer opinions about the strength of the state's case. And he analyzes those separately. As to the first category, he identified this variety of statements that Mr. Ballard made that explained the meaning of the inconclusive result. The state, of course, is arguing this is protected by the safe harbor, that the defense initiated this media frenzy because of the statement that was in their motion to continue. He finds that the defense's characterization was technically accurate, but highly prone to misinterpretation. It was technically accurate because, yeah, it didn't identify, but it also didn't exclude. So it left out a kind of important part of the context. And so as a result, you know, there was this media frenzy. He found that Mr. Ballard testified credibly about the effect of that statement in the defense pleading on the resulting media frenzy having a prejudicial effect on the state's case and the public's view of the state's case. And so those particular comments that he made, clarifying what the definition of an inconclusive result was, were responding to that prejudice. So for the first statements, he finds they are protected by the safe harbor. They do not violate the protective order. And so as a result, contempt was not proven. If all he had done is just say, inconclusive means you can't say one way or the other, click, he would have been fine. No issue. No issue. But the problem is then moving on to these opinions on guilt. And he identified specifically the statement made to TMZ where Mr. Ballard said that the state has ample evidence. They believe they have ample evidence to prove beyond a reasonable doubt that Tyler Robinson committed the murder. And he is presumed innocent, but we believe we'll overcome that. But ultimately, it will be up to the jury. He finds that Mr. Ballard subjectively believed he was in compliance. He thought. He didn't think he was violating the order. He wasn't like trying to violate the order, but that's not the whole story. That's not all that matters because that belief also has to be objectively reasonable under the circumstances. And he finds that this one was not. It was not objectively reasonable to believe that that was in compliance with RPC 3.6. And the reason why is because the response, if you're going to respond under that safe harbor provision, your response has to be limited very specifically to remediating the prejudice. And so going beyond that to our overall cases is really good, guys, is not limited. So he finds that stating that the prosecution has ample evidence to prove his guilt beyond a reasonable doubt was communicating an opinion that Mr. Robinson is guilty, and based on that, that violates the RPC. He says that Mr. Ballard made the cursory nod to his presumption of innocence as the rule requires, but then he immediately undercut it by asserting his belief that they would be able to overcome it. And those statements were not necessary to overcome the prejudice that resulted from the media frenzy about the ATF case and the bullet. So he's concluded that it was a violation of 3.6a. It was an opinion on guilt, that Mr. Ballard knew of the order he could imply, and he made an intentional statement in spite of that, and so his statement failed to comply. So therefore, the contempt has been proven by clear and convincing evidence. So as far as the remedial measures are concerned, what happens now, right? He's in contempt, but what does that mean? What are we going to do about it? It's civil contempt, so it means that the sanction that's imposed needs to be remedial. You can't just punish him. You can't, you know, do something to make him, you know, make him regret what he did. Like it has to be designed towards fixing the actual problem that resulted. And the challenge in any case, but certainly one like this where we're probably still like years out from the trial, okay, is that it's really hard to identify what's prejudicial to a potential jury pool at this stage. By the time we're picking a jury in like maybe 2 years, people may have very well forgotten about this. Like there's going to be a lot of hills and valleys when it comes to the media coverage and what gets attention and what grabs people's interest and so forth. And so in the grand scheme of things, the perception of the case and the publicity and all that at the point of trial is going to be very different than it is right now. There's going to be a lot more that's happened, a lot more that's gotten people's attention. And so, you know, how heavy is this going to weigh and all of that? It's you can't really predict that kind of thing. To me, it seems kind of implausible that it's going to have a huge outcome at that point in time. But you just don't know. You have to kind of wait and see. So the defense, of course, had said, well, strike the death penalty. We knew that they were going to do that. Of course, they're going to try that at every opportunity. That's a big part of what their job is to try to get the death penalty off the table. But the court says, no, we're not going to do that. We knew he wasn't going to do that. It's grossly disproportionate, as he said, but it also has some other problems, that it's not remedial. It doesn't fix the problem. If the problem is they think he's guilty, then that goes to convicting. It doesn't go to punishment. It's also by the fact that that's a fixed thing that you're doing. You're taking the death penalty off the table, period. No way to cure that. That makes it more of a criminal contempt type of sanction. And this isn't a criminal contempt proceeding. And then lastly, you have a separation of powers problem, because the executive, the prosecutor is part of the executive branch of government. They are the ones that have the authority to decide what defendants should be charged with. And the court's role is just limited to determining, do they have probable cause to be able to go forward and try to make their case. So for him to say, you know, we're not going to let you charge him with death penalty aggravators at this point is him, you know, kind of overreaching into decisions about what the defendant should be charged with or not that belong to the executive and not the judiciary. So eliminating the death penalty would be grossly disproportionate as well as legally unavailable under the circumstances. I noticed that comment, legally unavailable, because this seems to be a foreshadowing to the defense. Like I said, we already know they're going to try this. They're going to try this many times. We've seen it in lots of different cases. What was the one? It was Lori Vallow that was kind of the most high profile situation I can think of recently, where the Idaho court took the death penalty off the table for her as a sanction for discovery violations. And so that's part of the playbook. You know, we can anticipate that anytime they have the opportunity, the defense is going to be trying to argue, you know, take the death penalty off the table. Don't let them do that. But the judge here seems to be signaling that's not going to work. It isn't just that I don't think it's warranted here. He's saying it's legally unavailable. Like, you would have to go through a very different kind of process for that type of sanction to be available. So it seems to me like he's hinting to the defense, you know, like, we know you're going to try it, but you're not going to get it. You're not going to get it. Legally, he doesn't feel that it's in his power, because you're never going to get past that basic separation of powers problem. He still remains the judge. The prosecutor remains in charge of the charging decision. So interesting way of framing it, legal unavailability. So he rejects that as a punitive sanction that is not available. Instead, any remedy is going to have to address the potential effects on jury selection. So he has granted the OSC, and he's found that Mr. Ballard is in civil contempt, that appropriate remedies are likely going to include things like enlarging the jury veneer, expanding the voir dire process, allowing additional questionnaires. Basically, they're just going to have to confer about remedial measures, probably at a later point in time, is what I would expect when they're, you know, closer to the actual jury selection process. But frankly, things that we're like already kind of expecting anyway, right? Just given the high profile nature of this case, we already know they're going to call like thousands of people in as prospective jurors. They're going to have a massive jury questionnaire. They're going to do tons of individual questioning and group questioning and stuff like that. Like, it's going to be massive. The whole selection, and plus you have to have a death qualified jury, right? You have to have jurors that are willing to consider imposing death. Like, if you are morally opposed, principally opposed, whatever, you would not impose the death penalty under any circumstance. Even if otherwise you're perfectly fair and able to serve, you won't get seated on this jury. You'll be stricken because if that's the potential remedy that's on the table and you wouldn't be willing to do it, even if like the standards are met, the aggravators are proven and so forth, then you're considered not qualified. And so this has a strong tendency to skew capital jurors in a direction that is more prone to convict generally, more prone to like regard the defendant as lacking in credibility and stuff like that. There's like a whole bunch of research on this about capital juries and kind of how bad they are from the defense perspective. Interesting, there's going to be this compensation for reasonable attorney fees they're entitled to with the contempt finding. So they're going to have to submit an affidavit. What's that going to look like, right? Because this is all taxpayer funded anyway. This is not Tyler Robinson had to pay out of pocket to defend this. And so he's going to get reimbursement, you know, with a check to his personal account to make up for that. The county, you know, one kind of branch of the county is has hired these attorneys and is paying these attorneys to represent Tyler Robinson, and you know, another branch of government, I'm not even sure who, if it's the state or the county who funds the prosecutor's office. Basically, it's like this is going to be budgeting. This is going to be like budgeting magic. There may or may not be like an actual check that changes hands, but it's in some ways I think a little bit it's just what's the word I'm looking for? It's kind of an abstraction, you know. It's a different situation than when you have a private attorney and that you pay for out of pocket. This is going to be money shifted from one branch of government to another branch of government for whoever cares about that kind of thing. As far as future compliance, any future violations may result in additional findings or sanctions, of course. He does not intend to discourage legitimate statements that are allowed under the RPCs, but he has to recognize limits on the speech rights of the attorneys in order to protect the right to a fair trial. So that was the contempt. As far as the electronic media coverage, he's going to issue a ruling in writing midweek next week. So we will keep an eye out for that and have that posted on the Substack. Like I said before, I am not anticipating problems with the cameras. I think the cameras are very much going to be allowed, particularly given the indications we've gotten about how they intend to conduct the preliminary hearing in a way that is going to kind of minimize what we all get to see. So first, reviewing some of the protocols for the upcoming preliminary hearing. Wants to remind everybody, no portable electronic devices in the courtroom or on the fourth floor at all. So anyone who's attending the preliminary hearing in person, leave it in your car. We had to do that for Koberger, just leave it in your car. It's not going to be worth the hassle. Also, just, you know, this is a courtroom, behave accordingly. He is going to not want people to be making audible comments or gestures or, you know, shaking their heads or anything like that. Also, no pins or buttons or t-shirts, stuff like that. These are all fairly standard limitations on the process. You don't get to wear your, you know, free Tyler Robinson shirt in the courtroom during courtroom proceedings. That's pretty normal. You can wear it on the street outside. You can hang out outside like all you want. There might be like some buffer, you know, between where it's the courthouse property versus the public property and the traditional public forum of the like sidewalk and street, but you cannot wear it in the courtroom. They did ask for an exception for the electronics for the victim representative and her counsel. That was granted by the judge. And then Mr. Grunander also suggested that, you know, there's going to be sensitive information presented. So they want, he's talking about the videos, right? You're going to show the court the videos. The videos are going to have sound. So they're not going to show, he made it very clear, they're not going to show the videos to the courtroom. They're going to turn the screens away so that we don't get to see what is on the videos right now at this stage. But they're still going to have sound. It's going to be very disturbing. And so they want to be able to pause, let Erica and anybody, you know, with her, part of her team, exit the courtroom so they don't have to experience that. And then they can come back in once it's done. The judge has granted that in light of the heavy protection constitutionally that Utah gives to victims of crimes. And then lastly, Mr. Burt just gave us an update on that issue with the forensic experts. The reason why there's been no briefing and we don't need a ruling is because they've gone ahead and agreed to it. This is again, this is like an example of how, to me, this particular prosecutor's office is so largely unproblematic. Like, when you're used to dealing with prosecutors that will fight you on absolute bullshit, like the tiniest stuff that you're so clearly entitled to, and it doesn't, you know, it's just like, it's just reactionary antagonism. It's very much a thing. Like there are many prosecutors' offices like that. This one is not it. Okay, they will just say, we don't necessarily think you have a right to do this, but we'll let you. You know, we're not going to object. So they were able to reach an agreement for 3 of the expert witnesses to come over and testify. State clarifies that this doesn't mean we're not going to object to the particular questions that are asked, and that's going to this notion that the preliminary hearing, very specifically in Idaho, is not a in Utah is not a discovery tool. It's not there for you to just flesh out, you know, details of the case that you would normally have to do by a deposition or a witness interview or something like that. It is there for the limited purpose of establishing probable cause. And so if they exceed that and they start to get into, you know, fishing expedition stuff, that's going to go more to things like, I don't know, credibility, just whatever, things that might, the validity of the techniques, for example, would be a good one. Because we know from some of the prior rulings, the standards for how the judge considers the evidence at the preliminary hearing, it's very favorable to the state. He draws a lot of inferences in favorable to the state. He's not there to weigh, like, is this credible? Is this not credible? Is this good science? Is this bad science? So unless the evidence is something that's going to like completely undermine the conclusions as a whole, they're generally not going to be allowed to get into that at the preliminary hearing. So what I see this is kind of forecasting and previewing. We know for sure they're going to challenge this ATF analysis anyway, the tool mark comparison. And we know this because Michael Burt was one of the very first people ever challenging tool mark comparisons as unscientific back in 2009, when the National Academy of the Sciences did a big review of forensic science as a whole. And, you know, found just a lot of fundamental problems with the basic premises of a variety of these different kinds of techniques. And tool mark comparison in particular got and continues to get a lot of criticism because it's just it's very poorly structured as a discipline, extremely subjective, not really verifiable, not really falsifiable. It's just messy. It's like literally an eye test. I think it looks enough like this to be from the same gun. So we know they're going to challenge that, but they aren't necessarily going to be able to do that in the context of this preliminary hearing. Why? Because just because the science may be weak, you know, generally doesn't actually mean that he didn't, you know, get it right in this particular instance. It's the whole broken clock theory, right? He could still be right in this one case, even if in other cases maybe the subjective nature of the discipline means that the results that were reached were not reliable. That's kind of what I foresee this all kind of circling around. Then, of course, there's the other issues that have already been previewed with the scientific evidence that we know about, particularly with the DNA, the fact that Kathy Nestor told us at least some of this DNA that was recovered at the scene is complex mixtures. These are mixtures of 5 or more people, extremely difficult to deconvolute is the word they use for that, for mixtures, to like sort out who contributed what to the mixture and what is from one person and what's from another person. Much easier with a smaller mixture, 2, maybe 3 people. By the time you get up to 5, you got so much information and so much noise and so much just kind of limitations of the technology and how it works, to be able to reach real strong conclusions about it. So we know they're going to be challenging the statistical tool that the state has used to claim that this mixture includes Tyler Robinson's DNA. But again, you know, don't think they're probably going to be allowed to do that in the context of this preliminary hearing, just given the nature of it, and the fact that, like, yeah, okay, it might be sort of might be unreliable, but 1, that's a question for the jury, and 2, it doesn't necessarily mean that they're wrong in this case. But they're going to try, right? They're going to try, I think, with both of these. And that's what the state is anticipating. And the reason they're going to try is because they have to try to preserve this issue for appeal, for them to be able to go, you know, if Tyler is convicted, to go to the Utah Supreme Court, to go to the federal courts on habeas and say, this is a violation of his rights, to not allow him to challenge this, to challenge the validity of this scientific evidence. The Utah procedures aren't, you know, sufficiently protective of him. And so, yeah, it'll be fun. They're going to try it. They're going to get shot down. They're going to have to make their record and everything. All of that is going to be for purposes of future review. So I think, you know, we can kind of anticipate it's the same thing that we already saw, like with the hearsay motion, the one that was like not surprising whatsoever that it's denied, because the Utah law is pretty overwhelming that they get to do that. It's in the freaking Utah Constitution that they get to use the hearsay. Okay, like Judge Graf is not going to say, no, I'm not going to apply the Utah Constitution. It's beyond his pay grade. And so it's literally an argument that they made because they want to be able to present it to a federal court at some time in the future. That's what they're going to do with the same handling of the forensic experts. That's what I see coming. So Judge Graf, I think, also sees it coming, because he says, you know, I'm just going to remind everybody of the purpose of the preliminary hearing and the standard that applies to it, and that's what I'm going to be applying. And so, you know, remember that. Yeah, we know, but they also have their job to do, and they're going to do it. So it sounds like we are done with Tyler Robinson until we are ready for the preliminary hearing to start. Court will next convene on July 6th at 9:00 a.m. That will be 8:00 Pacific time. I'm definitely going to be streaming it. Yes, I'm taking it for granted that the cameras are going to be allowed. But I will definitely be there. It's going to be, even though, you know, it's going to be unsatisfying in the sense that we're not going to see a lot of what we want to see to give really definitive answers to, you know, the question of what happened. Still have to be patient, because we're not at that stage of the process. That is going to have to wait for trial. But nevertheless, just getting a little bit of an insight into even just how the witnesses present, you know, the ones that they call the overview of the investigation, the timeline. You know, there's been all kinds of stuff out there about the timeline of the arrest and so forth. That is absolutely, without question, going to be established at the preliminary hearing. You know, what happened when he turned himself in, and all of that type of thing. So that at least, you know, will hopefully resolve some of those questions, allegations, etc., that are out there vis-a-vis the timeline of the arrest and the Discord confessions and so forth. But as far as how many of the details we're going to get to see, it really sounds like they're going to kind of minimize it. You know, the judge now, he's backed away from the comment that he made, obviously not on Monday because I wasn't covering that one, but the hearing before. He made a comment that the exhibits were going to be sealed. The preliminary hearing exhibits would be sealed. But it sounds like he's backed away from that a little bit and says, well, we're going to take it on a case-by-case basis, a piece-by-piece analysis instead of a blanket rule that none of the exhibits are going to be available. He's going to take it as each one is presented, and so that I'll have to go and look at what the standards are in Utah for that, but it's likely going to be based heavily on like how prejudicial would this be if it's out in the public arena before trial. And so given that, it means, you know, the stuff that you most want to see to know what happens is the stuff that you're least likely going to be able to see at this point in time. So, you know, we're not gonna get everything we want, but we will definitely get some progress. We'll get to see how just, you know, people handle themselves. We've seen a little bit with I mean, the prosecutors testifying it's always like unusual, but we got to see like how Mr. Novak does questioning and stuff like that. We'll get a little bit of a better feel for the parties and how they're going to conduct this process, get a little bit more of a feel for the evidence, likely clear up the timeline of the arrest and the confessions, alleged confessions. So it's going to be exciting. It's going to be you know, by far the biggest new development in the case and the best, clearest insight we have into the basis for charging Mr. Robinson that we have received to date. So I am very much looking forward to it. It's going to be probably a good part of the week. You know, they have the whole week set aside. May not take the whole 5 days, but it's probably going to take a couple. So we will be here for it. Well, that's our wrap up of what happened today. Let's see what you guys have had to say. The Trababides, ever been to the Doritos farm? It's a cool ranch. That's a good dad joke. That's a good dad joke. I like it. Giselle D, thanks for asking my question, Jeff. I appreciate you both. Thank you for asking questions, and thank you for the acknowledgement. We appreciate that very much. Justin Wright 7297. Nick Stero released a video yesterday explaining the details of the judge's answer. MLS also explained last night on his LL&L stream. I think this is talking about the reckless Ben. Yeah, I got a lot of catch up to do on that one. I'm still just, like I said, only like 10,000 foot familiarity of kind of what's going on in the first place. But it does sound like they had the hearing for the permanent order and loosened it significantly. So that is a bit of a relief, but I would like to hear more about the details of exactly what happened, how all that went down. Ginger Puff had gifted a bunch of memberships. Thank you so much, Ginger Puff. We love seeing the chat turn green. Mindy Ann 44 helped us turn the chat green. Court Ed helped us turn the chat green. Thank you so much for that. Laws in order, jury taint, lols. It's your mom's favorite kind. Mom's favorite kind of jury. Matthew Felty 3340. Ample evidence TMZ is trash, in my opinion. Why answer the call? That's a great question. You know, why would you go to TMZ? I don't really know the thought process behind going to TMZ. It seems very foreign to me. Like, I would think I would want to go to credible sources. I would want to try to go to, like, you know, well, now if I say anything, I'm going to get yelled at by the chat, right? Can't identify because, yeah, the mainstream media just generally sucks in a lot of ways. But surely they suck less than TMZ, right? TMZ is gutter trash. The only reason I can think of is just because it's got reach. You know, they know that not everybody is going to be reading the New York Times or watching Fox News, trying to keep things a little even here in terms of our sources. But you know, a lot of people will skim the TMZ. I mean, it's like the pre-digested food, you know, it's not difficult to incorporate. So that's the best reason I can think of, is just they thought it would get out to lots of people. But at the end of the day, perhaps it was not so helpful that it got out to lots of people, because those were the comments that were particularly problematic, leading to the contempt finding. The Purnell, 1799. I am dying to read about the state's uninvited objection, lol. Can you please fix the link to entry 616 in the Substack? Thanks for all you do. Let me make a note. I will get on that. Sometimes, yeah, it's not the most user-friendly medium sometimes, and things get a little confused with what's where, and also I get a little confused sometimes with what I'm looking at. So I will check and make sure that I have the right document in the right place, and if it's not there, I will correct it. I know that I have it because I know I looked at it. The uninvited objection was, their argument that the death penalty being taken off the table is not an appropriate remedy for contempt. And it was the defense who then filed a response to that, who called it out as an uninvited objection. So didn't appreciate the state volunteering its thoughts about the potential remedy. But so I know I have it. It just may not be in the right place, and I will work on fixing that. Kang the Conqueror 2025, is the jury pool hopelessly tainted at this point? I don't think so. I really don't. I mean, the reality is like every high profile case is kind of like this. People get very strong opinions, but it's a minority of people. The majority of people are not deeply invested in this case. There's going to be people that care so little about criminal cases in general, this case in particular, that they aren't paying any attention to it. They don't care. It doesn't register. Maybe that's not a ton of people, but there's going to be some. Then you're going to have the people that are just, probably the majority of people. They read what's in the news. They see it, like, observe it and move on. So they have like a superficial kind of awareness of what's happening, but again, just different degrees of caring about it. And if you don't care about something, it's less likely to really have an impact on you and stick with you. Then there are the hardcores like us. We're here watching, every hearing and reading all of the legal documents and that type of thing. It seems like there's lots of us because, it seems like we're the majority because we're, here in chat and we're on Twitter and everything like that and talking about these details. But that is an echo chamber, and we run the risk of assuming, that our echo chamber is bigger and broader than it is. We're not the majority. And so the process of jury selection is really going to be geared in large part towards identifying us. Finding us, the people who really are interested, have paid attention to a lot of the ins and outs, and then evaluating. Are you still objective enough to be able to serve? Are you going to come in with your fixed opinion about what happened that you aren't going to be moved off of? Or are you going to come in like having watched it, but being willing to see what is presented and what the ultimate case actually is? So no, I don't think the jury pool is hopelessly tainted. Again, we're still years away from this trial happening. Best case scenario. And so just to me, no, the prosecutor shouldn't be making comments like this. And I do think that Judge GRAF handled it correctly. I think this is exactly what you want to do. You find him in contempt, but there's no real consequence for it other than just the kind of threat that if you do it again, we might have a bigger problem next time. And also just the sort of public, it's like a public reprimand kind of, you were bad. Okay. It hurt his ego a little bit, I guess. But, is it like meaningfully damaging? Not particularly. Not particularly. I'm sure there's, I can think of certain prosecutor pools where this would be like a badge of honor. Oh, you've been found in contempt because you did, pro-prosecutor things. But, it's enough to like have that discouragement to don't test me, don't test me, don't push my limits. You better be real freaking clear on what the boundaries are if you're going to decide to talk. But is this the kind of thing that has a massive impact on the jury? I really don't think so. I really don't. Okay, the prosecutor says they think they're going to be able to prove him guilty. To me, that their argument that like that's what prosecutors are supposed to think, it carries some weight with me. And not that like that's an excuse for making the statements, but just in terms of like how prejudicial is it? Well, yeah, I do expect that they think he's guilty. Of course they do. That's why they've charged him with a crime. They think they're going to be able to prove it, but ultimately it's going to be up to the jury, and the jury is going to get to decide. Like, it's just not really, it's not really that egregious, and it's not particularly groundbreaking to me. That said, of course, they shouldn't be doing stuff like that at all. But is this going to be the straw that breaks the camel's back of the jury impartiality? No, I don't think so. I don't think it's the kind of thing that will change the opinion of anybody, that is really like already paying attention enough to be aware of this process and care about it. That's just my thoughts and my opinion. I'm just one person, and you might disagree, but that's my take on it. Well, so not a super long hearing today. I definitely appreciate that. This was there's a little bit of repetition in this order, but not nearly as bad as some of them have been. What was the one I was just paying attention to? I think it was the hearsay. I think it was the hearsay order, where I'm like, I'd like read the same thing like 3 times. By the third time, I'm like, I've already read this so many times. Why are we saying this again? I get it. It's like he's got to find it, and he's got to tie it into his analysis and stuff. But it just does come off as a little bit repetitive, but not so bad this time. I kind of kept that fairly minimal, but again, nicely structured, well broken down with it's like got an outline format. To me, I find that so easy to follow. Category 1 of statements, category 2 of statements, legal elements 1, 2, 3. It's just a very systematic way of working through legal problems. So I do appreciate that. Guys, I'll be keeping an eye on the docket for obviously the ruling on the cameras, but anything else that may come up in the meantime. Question here, Andrea, what else will you be covering this summer? Sorry if you've already said. This is a hard question for me right now, because one, I am like mentally not quite in my what am I doing right now stage. But there's definitely a lot of things that I'm interested in and watching, at least casually. I'm here in LA, of course, because of the divorce from hell, Mr. Fantastic and his alcoholic ex-wife. I just had a legal battle to get access to court exhibits, which I won overwhelmingly in dominant fashion. So I'll be getting court exhibits probably sometime in July and doing some work on that. I'm very interested in Luigi's trial. Luigi's trial starting in September, assuming it goes forward. There's been like reporting around about, oh, there's plea negotiations and stuff. This is another one of those things like of course there are. There should be. Like nobody's doing their job if there are no plea negotiations. It doesn't mean that somebody is acknowledging they're guilty. It means that they're thinking about the risks of trial and trying to evaluate what their options are. Literally part of your job as the attorney. But barring something like that, then there is going to be a trial, and I'm interested in that. But I don't really know yet how that's going to go, right? They're not going to have cameras in the courtroom, so that makes covering it from a distance a little bit of a challenge. Not real sure I want to try to get a press pass and go hang out in New York to go to the trial in person. Haven't ruled it out, but not really thrilled about the idea. I don't know. So I'm keeping an eye on it to sort of see what might develop with that. What else? What else am I interested in? Of course, I saw Barry Morphew just got kicked. That trial just got kicked down the road. So that won't be happening anytime soon. Courtney Clenny is still like lurking on the horizon down in Florida. That case, haven't checked in on that one for a little bit to see what's going on. But that one should be gearing up to go to trial pretty soon, and that one is going to infuriate the hell out of me. That one's going to be just the Darvo trial from hell. This woman, oh God, don't get me started. I've been, one of the things I've been trying to look at and dig into a little bit deeper. I'm interested in the Mackenzie Shirilla, the whole appeal issue, right? She's the one that drove the car into the wall and killed her boyfriend and her friend, and she got convicted of, I think, second-degree murder. And so she had filed an appeal and she lost, and then she filed for post-conviction relief, like habeas kind of equivalent. And that was denied. That was like basically dismissed because it was filed 1 day late. So she's, I expect, going to continue to try to fight that. But I'm not so interested in that. I'm really interested in seeing, one, what her grounds were that she argued on appeal in the first place that got affirmed. And then what was the actual like allegation in her petition? What was she arguing as the reason for saying the conviction should be overturned? So I'd like to hunt down those documents if I can, and try to get a little bit more insight into that, and just because it's one of those things, you see a lot of stuff about the case, but when you don't have access to the direct primary source material, it's hard to gauge, like, because I'm just hearing people's opinions and people's takes, and I don't really know, how good it is. I don't know if she had a good defense. Like, it does seem like it's one that's thin on the intent side, the mental state side, but that's not unusual. There's plenty of cases where intent is largely circumstantial, but what was it based on? Was that good? Was it bad? I don't know a lot of those details, so I am interested in looking into that. Those are the things I can think of right off the top of my head. There's probably like something super obvious that I'm forgetting about. Anything real obvious that I'm forgetting about? Of course, not that I can think of right now, but those are just a few of the things that I've been paying attention to. Richard Allen is going to have his appeal argument in September. Definitely going to be paying very close attention to that. A good appellate oral argument, man. That was my wheelhouse. That's what I did for a lot of years. And so these attorneys that he have are he has are reputed to be extremely high level public defenders in Indiana at the appellate level. So I'm very interested. I was very impressed with their briefing and how they handled it. But I'm curious to see what they emphasize and what they don't. My view of as the outsider of the appellate arguments might be different, than their view. Like I look at it and I see the argument about the pretrial confinement. He was kept in solitary confinement for 13 months as a pretrial detainee, not convicted, and severely deteriorated because of that. Legally speaking, that doesn't seem like the strongest issue to me, but when I read through the briefing, I just get this feeling that that's the one that they care about. They really care about that one. They really want to win on that one. I just don't know if they're going to. So seeing the oral argument and what they choose to focus on and how they focus on it and stuff like that can be very interesting to see. Afro Man has his appeal. That I'm keeping an eye on too. I will just say I like to give shout outs where appropriate, and the clerk in the Adams County Court over there in Ohio, one of the best, like most responsive clerks that I dealt with. You get a real variety in court clerks, and of course you have to be very, very careful and tiptoe around court clerks a lot, because if they decide they don't like you or whatever, they can make things very, very difficult for you to get court documents and things like that. So some clerks, Looking at you, Carroll County, can be a little bit of a challenge. But then you get a really good one, like this Adams County clerk who like responds to the email almost instantly and is like super helpful and volunteering. Here's where you need to go and here's who to talk to and stuff like that. She was great. Like already loved that woman. So looking forward to the Afro-Man appeal and seeing what else is going to be argued with that one. It's going to focus primarily on, I think, his counterclaims and the dismissal of his counterclaims. So yeah, want to do a little bit of digging into that. I think that's I mean that's a pretty good list, right? That's a decent list of things. So those are all things that I am interested in the short term. Guys, oh, we got another, oops, that is. Two Truth for Liberty saw this at Misris XOXO. Andrea, I'm just getting on, but I do live in New York City. I could always get a press pass and go to the case for you if you want it. I already work for a criminal defense attorney too. Hey, I'm not going to say no. That sounds awesome. And that's always kind of been the challenge that I found with, you know, following coverage of a criminal case, is that a lot of the media that gets in, they don't know what they're doing. Like they don't understand criminal cases, they don't understand the courtroom, they don't understand the legal process, and so they don't know what to pay attention to and what matters and what doesn't. And things often get like distorted and misunderstood and misinterpreted. So you have the background with the criminal defense attorney and you've been around that block, you know, you're going to have a much better perspective, I think, than probably the majority of people in that courtroom. So I'm absolutely not going to say no. Keep me posted if you decide to do it, because always looking in cases where we're not going to get the cameras and stuff like that, always looking for good reporters from inside the courtroom. That was one of the challenges I think I'm still having with the Carmelo Anthony case. You know, I'd like to look more into that case, but the judge kept the cameras out, and so until there's a transcript available, there's really no direct source. And I just, you know, I'm very hesitant to rely on reports from people inside the courtroom when I don't know anything about their reliability or anything like that. So, oh yeah, Sarah Grace Patrick in August. Yeah, I've heard about that one. I'm interested in that one. That's the girl whose parents were murdered. She gets charged. She was like on TikTok, I think, on TikTok, and like trying to get TikTok influencers to cover her parents' case. Then she ultimately gets arrested and charged. I think that was hers. There's always all kinds of interesting cases going on. There's always more than I can really pay attention to. It is summer and I like being outside. I'm an active person. I'm the kind of person that winter is always a little harder for me, especially like living as far north as I do, just because the days are so short. You don't get as much time outside and stuff. So when I have that in summer, I like to really dive into it. And that means I don't necessarily like want to sit inside and watch a trial. Unless it's like a really, really good one. I don't know that I'll probably be doing like intense trial coverage until later on in the year. I'm actually not even sure that there is like really a super interesting trial, like interesting to me, trial to watch in the coming days. But you know, if something comes up that's intriguing enough, maybe I'll sit outside on the patio and stream it or something. I won't rule it out, but maybe not, because you see what happens when I'm not in my normal studio with my normal tech stuff, and doesn't always work out the best. Kang the Conqueror 2025. Have you followed the conspiracy theories around this case? Do you think Erica had a strong defamation case against people like Candace? I mean, you can't avoid it. It's kind of everywhere. I see it. I don't follow it. No, I'm not particularly interested in it. I'm interested in what happens in the courtroom. My perspective on criminal cases is that if there is a problem with the state's case or the state's evidence or the state's timeline, the person and people with the strongest incentive to identify it and point it out and, you know, wave their hands and get our attention is the defense team. I defer very, very strongly to the defense team when it comes to the strategy of the case and what they think is worth raising and what isn't. It's not to say defense team can't get it wrong, you know, but there are just some things that are so obvious it's very hard to miss. And things like, oh, if he was arrested, you know, before the Discord confession and so forth, like that's an obvious enough, especially like when the whole basis for this is coming from things that the defense has said in their pleadings, like it's, you know, this tea leaf reading of defense pleadings to like infer stuff about, but the defense has like never actually, you know, said, hey, there's a problem with the timeline, or hey, our client, they sound like our client is factually innocent, you know. So I tend to defer strongly to the defense team, and that's very much the case here, just because of, you know, what I've looked into with these particular lawyers. Not so much Kathy, although Kathy is she's got a much more impressive background than I think she gets a lot of credit for. She takes heat because I think a lot of it is tone, and I do agree with that. She can be a little bit obnoxious, but also she might be a little on the gray area of just the kind of shady stuff, you know, that she might be willing to do in a case. This is just what I hear, not my personal, because I haven't looked at her that closely yet. Still gotta go catch up on Corey Richens. But definitely Mr. Burt and Mr. Novak, these guys are cream of the crop when it comes to capital defenders. These guys are the best of the best. And so I'm going to defer very strongly to them about what the case is about. And so far, I haven't heard anything from them to suggest that this case is about factual innocence. It sounds a lot more like this case is about waiting until trial to see what the evidence is, right, publicly, and judging him. And that means that from the defense standpoint, it's much more likely to be a mitigation case. That's really where their focus is. It's not going to be about, is he not guilty? It's going to be about, should he get the death penalty? And that's not uncommon in death penalty cases, that's kind of the primary strategy. So I don't pay attention to conspiracy theories any more than I have to, just because the algorithm serves them up to me, and so I see them, and I don't really take them any further from that. So I'm not in a really good position to evaluate whether Erica has a strong defamation case against somebody like Candace or not. I don't pay enough attention to what Candace says. Frankly, sorry for those of you in the chat who love Candace. I could give a shit what Candace says. I'm not remotely interested. If there's any good information there, it's going to come out in court, is my perspective on it. So I know other people disagree, and that's fine. But I've really never followed the more like sleuthing side of true crime. Not because, you know, there have been situations, I think, where, you know, sleuthing has been helpful. It's come up with information and tips and things like that have benefited the case. But I feel like that's the exception more than the rule. I think that the rule is far more often you have the Reddit we did it situation with the Boston Marathon bomber, where like, actually you guys might have gotten a cop killed, you know. Not really ideal. So there's very much like risks and benefits with that kind of approach to true crime. So I've never really been kind of interested in that side of it. I'm just much more about the court process and trying to understand it and help other folks understand it, and what it shows us about the process and the underlying merits and all that. So yeah, somebody would need to be more familiar with what Candace has said to know if there's a strong defamation case. That said, what I can say, Erica is a public figure. This case is a case of great public interest. There is sometimes a fine line between opinion and fact. What I am inferring based on circumstances that are presented to me You know, we're allowed to do that. We're allowed to look at evidence and think certain things about it or judge it in certain ways. And that's not going to constitute defamation. But there is, of course, a line that can be crossed. And if you are asserting things as factual that are not factual and are damaging, then even for a public figure, yeah, that could be an issue. So, me myself, like I don't understand the whole hostility to Erica. I really don't. I don't know where that came from. I really don't. It's something that I've noticed. It seems to be kind of becoming a thing more in criminal cases, that there is I don't know, just a like backlash against the victim. I'm thinking about this recently with the Carmelo Anthony case. A lot of similar things. The dad, like okay, sorry guys, there's no question that a dad whose son is killed is a victim. There is no question that a woman whose husband is killed is a victim. Okay? This person is a victim. Period. Full stop. And so to me, like you just want to be very, very cautious about adding to the pain and suffering that this person is already experiencing. Now, yes, it's very much the case that sometimes the victim is in fact a perpetrator, you know, for example. But I've never been real inclined to assume those types of things real easily. And that's likely just related to I'm a defense lawyer. I don't make accusations, I defend them. I'm not comfortable with the j'accuse, you know, I want to be very, very sure of my position before I go accusing somebody of wrongdoing. And a big part of that is because when you work with crime, and a lot of crime, you deal with so much pain and so much trauma that you know, just the idea of adding to that is not particularly appetizing. But other people are far more comfortable with you know, drawing those inferences, making accusations. Some people love to judge. Some people love to judge and point fingers and things like that. That's just not me. So whatever, people are going to do what they're going to do, and there are certainly channels that will feed that particular appetite, but it won't be here. Oh, guys, I have I don't know, a little over an hour to get out of this hotel here and get on my way home. Get on my way home. This has been a great trip. I said yesterday this was a 10 out of 10 trip to SoCal, as trips to SoCal go. It is a little bit of a Babylon here in Los Angeles. I'm always so ambivalent about it here because there's so much cool stuff, and yet at the same time, it's just so degraded. Like the kind of archetype of that for me is going through the downtown. Classic downtown Los Angeles has some amazing architecture, and especially the Art Deco. They have this amazing Art Deco architecture, and it is nearly all like fallen into significant disrepair. It's tagged up, the windows are boarded up, everything's vacant. And you know, the streets, California streets are like notorious, the potholes, the cracking, you know, the streets are poorly maintained, there's trash around, like there's weeds growing up in the sidewalk. It's just this combination of like you're in like very close to paradise here. I mean, at least with the water being piped in, right? If they weren't stealing the water from the Owens Valley, it would not be anywhere near so nice to live here. But with the irrigation and the water and everything, it's like paradise here. And yet it's not cared for, you know, it's not cared for. It's kind of being allowed to decay. So it's always a little kind of a mixed thing for me to come down to Los Angeles, but this has been a great one. This has been a good one. Wonderful time in Sequoia. Great win in court yesterday. Always fun. Can't really complain about that. But I am looking forward to getting home, getting back to my kitty cats, my dog, my husband. No, I didn't mention him third on purpose, guys. I know what you guys care about. And then, all of the just, simple life things that we have going on at the homestead. I think we're probably about wrapped up with apricots, but it will be plums next, and always stuff going on in the garden. I have my Japanese pine. I have my garden pine that I'm pruning to a Japanese tree style. It's time to get some work done on that. Just as far as like the season and where the tree's at with the growth and things like that. Now's the time to do some work on that. So that's how I'm going to be spending a lot of my time, and maybe not so much, in front of the screen for at least the short term until we get to this preliminary hearing, which I will definitely be here for. The apricot harvest was bountiful. I have one tree. I have this one tree. I have two trees that are quite old. They were already probably 20 years old when I bought the house, and then another one that I put in that's just starting to produce. So the two large trees, I have one of them like pruned to perfection, thinned to perfection. It was just fantastic. It was like finally, it takes a while. The tree had gotten like overgrown, really tall. It takes a while to bring a large fruit tree back down. So that's been like a years-long project in the making. Finally got it like to perfection. So that tree was awesome, like very easy to deal with. The second tree, haven't gotten so far on the work with it. Also didn't finish thinning it this year. So that one is a little bit of a different situation, but we are getting through it. There was tons and tons and tons of apricots this year. Always kind of a blessing, I think. We're at in Washington, we're at a very marginal like elevation, latitude, probably more latitude for apricots, because we'll get late freezes, and so it's very, very common to get a good fruit set, but then it'll freeze and you'll lose everything. But that hasn't happened for a few years, so we've been blessed with many years of good apricot returns. I am a massive dried apricot fangirl, but it's got to be like the real dried apricot, not the Turkish apricot, not the ones that are like steamed and then sort of like, I'm not even sure how they preserve those, like what the preservative is. Like I like them sun dried, not quite leather, but nice and chewy. Oh, it's the good stuff. That's one of the things that gets stuffed in my hiking backpack between dried apricots and Skittles. Man, that's your best hiking fuel. I'm going to be looking into some hikes too this year. Some long hikes. I'm not going to do anything major this year, but I like to look down the road to next year, especially now with this trip into Sequoia. So where I was in Sequoia was this place called Mineral King Road, and it's this very long road that goes up a river valley, and it starts like right before you get to the main park entrance. But it is part of the park. It's just considerably less trafficked, and it doesn't have as many of the big trees and stuff like that, but it does still have some groves and some big giants and everything like that. It's just, less touristy. So anyway, that's where I was, and I did some wonderful hikes while I was in there. And one of these hikes was to a place called Monarch Lake. And Monarch Lake is quite high. It's about 10,000, somewhere between 10,000 and 10,500 feet. It's right below what's called Sawtooth Peak, Sawtooth Pass. There's a pass that goes over there, and that gets you into the high Sierras. And this was just a gorgeous hike, gorgeous area. Really, really enjoyed it. And I was kind of peeking around in the trail system, and I'm like, I think there's a way that you could get from here onto the John Muir Trail. And I've wanted to hike the John Muir Trail for a long time. But that's a big one. That's like a big through hike. I want to say it's somewhere in the ballpark of about 260 miles. So you're talking about, a month, and one of those things where you have to like arrange to have supplies shipped in and stuff like that. But it goes basically across the crest of the Eastern Sierras. You go through Yosemite, like it looks spectacular. You go through Kings Canyon, you know, I'd love to do some of that sometime. But it's hard to coordinate, one, with just the logistics of getting food and stuff, but also this is permit area. You have to get a backcountry permit, and that can be a little bit challenging to arrange. So I've got that kind of in my long-term vision to look forward to, but you know, you need to be ready for something like that. You need to practice. So I'd like to do some shorter stuff closer to home. You know, maybe around Mount Rainier, maybe do the Wonderland Trail, something like that. I don't know. I'm gonna figure it out, but get some good outside time and get some of these dried apricots taken care of. Oh, guys, thank you for joining me today. Do appreciate it. Sorry I wasn't, you know, here for the Monday hearing, but doesn't sound like there were really any big surprises with that one. Really not surprised with this one today either. It's seems, yeah, pretty consistent with what I've come to expect from Judge Graf. So we look forward to the preliminary hearing, guys. I know you'll be there. I will be there. Looking forward to it. Thank you to the mods very much today. I don't always get to follow the chat real closely, but I know some days the chat is a little spicier than others, and nothing brings out the chat spiciness like the Tyler Robinson case. And so while we are big advocates of the First Amendment here, we like everybody's free speech rights. We also want people to exercise them in a way that is not, you know, abusive to other people. Just a fairly light "don't be an asshole" rule, but it does sometimes create you know, some work for the mods to keep track of everything that's going on and make sure that things are getting a little out of hand. But we always like a good discussion here. We like differences of opinion. We like you know, people to be able to speak freely, and think that ultimately there are benefits from doing that, even if you know, you don't like what other people has to say. You can learn a lot from being exposed to it anyway. And it's just so easy to get siloed in this day and age, you know, and only hear the stuff you want to hear. So it doesn't mean you have to accept things. It's misattributed to Aristotle all the time. I think this comment about, you know, the sign of intelligence is being able to entertain an idea without accepting it. That's not a thing that Aristotle said, but it's still a good idea and a good principle. And so I buy into that. I think it's important to hear what other people say, but that doesn't mean that you have to believe it or that you have to agree with it, but it will make you stronger to think about why you don't want to agree with it or accept it and so forth. So all wonderful benefits of the chat, and thank you so much to the mods for everything that you do to keep that running smoothly. Sorry again for the mute issue at the beginning, but don't think we missed anything substantial. But now at least I'll be attuned to that next time we have a WebEx, that it might mute me automatically without me knowing it. Guys, I'm off. Appreciate all of you. Thank you all for joining me. Thank you for your interest in the case. Thank you for your interest in the justice system. You know, whatever your position is on this case, people want to see justice be done. And I think that that's important to bear in mind. I try to give everybody the benefit of the doubt, assume good faith until I have a really good reason to believe otherwise. It kind of goes hand in hand with that whole, like, I'm not a Jacques Hughes kind of person, but I realize it's not always the case. But I think it's just a better starting point to come from, to assume that even if people disagree with you, they are doing it in good faith. And so I do think that's an important part of this case, is just the hunger for justice and to see and to understand the process. And so the fact that all of you care about that, it matters. You know, this is we're in an era where our institutions are kind of crumbling, you know, and our faith in them is shaken, and that's maybe a little dangerous, just from a standpoint of, you know, keeping our civilization in a position where we can continue to have unity as a country. I'm reading, just a little aside, I'm reading Grant's memoirs right now. Don't tell Jeff, but I totally have like a girl, I have a crush on Grant. Like Grant is amazing. Okay. But anyway, I'm reading the memoirs, and it's just been interesting to get back into, to get into the mindset of that era, and the lack of unity and where that can lead. It's not a place I think we want to go to, but our institutions have responsibilities to us too. It can't just be a one-sided, we have faith, period, regardless of what happens, and leaves the institutions to abuse us. Unfortunately, there is a lot that the legislature has done, the courts have done, the executive have done to challenge our faith. But it's really important, I think, for us to work to maintain them anyway, if we want to hold together as a civilization, and not need to be out there trying to find the next General Grant. And I don't mean the General Grant that's up the road in Sequoia. He died penniless and friendless, broken, no cats. Penniless only in the sense that, he had finished his memoir. He finished this memoir like days before he died. He died of throat cancer. But Mark Twain published the memoir, and it made his widow and his surviving children like millions of dollars. It made them so much money. Broken, I don't know about broken. Cats, he's a rural man, I'm sure. I'm sure there were cats around. I'm sure he had a barn cat. I would guarantee it. I would bet my life, maybe not my life. I would bet money on Grant having at least a barn cat. Oh, guys. Thank you again. Appreciate all of you. It's always a good time. You make it fun to watch court together and talk about it and stuff. So thank you all for that. And yeah, if nothing comes up in the meantime, I will see you guys on July the 6th, 9 o'clock Mountain Time, for the preliminary hearing. And we will take it all in and break it all down. So guys, have a wonderful weekend. Have a wonderful 250th anniversary of our great nation. And I will see you on the 6th. Bye, everyone.